All right, you may proceed.
I will be concluding my remarks this morning so that you have some sort of timetable. I'll tell you a story right now. The story is about a man who I know, and this man grew up in an abusive environment, an environment dissimilar in some ways from the defendants. This man grew up in a home where his father beat him constantly, and he beat his mother as well. And when this man was 12 years old, his mother died. She didn't die from beating. She died from complications of a hernia operation, but she died nonetheless. And he was left in the home, and the only adult was his father, who beat him all the time. His older sisters tried to look after him, but they wanted out of the house too, and so they did what women often do. They married young, and they left the house. When this young man turned 17, he was tired of the beatings, he was tired of the abuse, he was tired of his father. And so he did what many young men do. He ran away.
Well, I don't know that yet, so I'll have to hear a little more.
He ran away from home and joined the Navy. Since he was only 17 years old, he couldn't be in the Navy, and so he spent one more year in high school. And the minute he turned 18, he ran away from home. He went back very rarely to see this father of his, and over the years, he became a naval officer and then left the Navy and spent 35 years in the Navy Reserves. 35 years after he left home, his father was dying. He was an old man. He was still a nasty man, but he was an old man. And he called for his son, and he asked his son to come to him. "Please come to me, son. I'm dying. I want to make peace with you." And the son said, "No, I won't. Not after the way you treated me." So when Dr. Conti says that children who are abused generally love their parents, that's not true. This defense in this case is extremely...
Objection is overruled. You may proceed.
The defense in this case is extremely objectionable. For all the children who've been beaten to within an inch of their life, for all the children who've been scalded with hot water as punishment, who've been burned with cigarettes, who've been locked in rooms for days at a time, years at a time, and not fed, for those children who became adults. And let me say that throughout this trial, you've heard the term "the boys," to the point where I'm sure that in your own mind you refer to the defendants as the boys, but they're not boys. On his next birthday, Lyle Menendez is going to be 26 years old. He was 21 years old, almost 22 at the time that he murdered his parents. And for all those children who were severely abused, for all those children whose parents put them in the hospital in truly life-threatening situations, this defense is an offense. And for those children who got out of the house and made lives for themselves and became productive members of society, this defense is an offense. Individual responsibility, responsibility for one's actions, is the hallmark of becoming an adult. And in our society, we say adults are 18 years old. 18-year-olds in this country have been drafted and sent to die for their country. 18-year-olds are entitled to vote, they're entitled to marry, they're entitled to own property, they're entitled to enter into contracts, they're entitled to do everything a 35, a 50, and a 90-year-old is entitled to do, because 18-year-olds are adults in our society. And so don't be tricked by the repetition of the term "the boys, the boys, the boys." And how many times did you hear the murders referred to as the deaths? I often ironically thought of them as the day you made yourself an orphan. These are murders, ladies and gentlemen. And the repetition by the defense of terms such as the boys and the deaths is nothing more than the same thing that happened if you were late to school when you were a kid and you had to write on the blackboard, "I will not be tardy," 100 times. The repetition is done so that you will think that these men are boys and that these murders are deaths. And that is the purpose of the repetition, and that is the purpose of the use of the language. Keep in mind that this is the best defense Daddy's money could buy for his adult sons. Now, I have on the board a tree that was used by Mr. Burt in his argument, and I believe Ms. Lansing as well. And not very subtly, Mr. Burt told you that in order to avoid this portion of the trial, all you have to do is not find the defendant guilty of one count of first and one count of second. And he wasn't very subtle about it. He's basically telling you that if you want to see one of these kinds of trees this year, ladies and gentlemen, all you have to do is find one count of first and one count of manslaughter, and you can go home. And that's what he's telling you. And the thing about this is somewhat troubling is that you're going to have a jury instruction that the judge is going to tell you about today. And this is what the instruction says. In your deliberations, do not discuss or consider the subject of penalty or punishment. That subject must not in any way affect your verdict. Penalty or punishment, these two penalties, is something that you cannot consider at all when you are back there discussing guilt. If there is a second trial, then these things become relevant. And what the defense attorney is trying to do is, if you want to get out of here, if you want to go home, I'll show you the route out of here. Well, after the amount of time and effort that you have put into this case, that would be irresponsible. The defense is giving you a chart talking about all the things that do not constitute beyond a reasonable doubt. Well, we prosecutors have our own charts. And here's the prosecution version. This is the counter chart to the defense chart. What this proves is nothing. What this proves is that lawyers use words. That is the tool of a lawyer, are words. And just as Ms. Pizarro said gotten off, and the defense attorney refers to it as acquittals, and people being found not guilty, lawyers use words. That is the tool of a lawyer's trade. I do the same thing. But let me just show you this chart quickly. Beyond a reasonable doubt is here. Beyond any shadow of a doubt is a higher burden. Beyond any doubt, absolutely certain and 100% certain. So you see, just as the defense can have their charts that show all the things that are not reasonable doubt, we also have a chart to show you all the things that are also beyond reasonable doubt. So all this proves is that in the battle of the charts, we have ours as well. Mr. Burt complained about the fact that the people used Exhibit 7 here in their argument. And so I put up a photograph that's been introduced. In fact, there are two copies of a picture of the Cookie Monster. It seems to me that this picture of the Cookie Monster sort of sums up what the defense has been trying to do in this case. The defendants made this mess. The defendants slaughtered their parents. And they put in photographs as ludicrous as the Cookie Monster in hopes of preying on your sympathies, in hopes of confusing the issues, in hopes of making you feel sorry for the defendant. Well, the judge is going to instruct you, and one of the first instructions he's going to give you is that you are not to be swayed by sympathy, passion, or prejudice. The fact that Lyle Menendez had the Cookie Monster when he was 16 years old is something you might want to consider in a second trial. But it's nothing for you to consider in this trial. And I ask you, when Lyle Menendez bought the $70,000 Porsche, did you take the Cookie Monster for a spin in the Porsche? One of the things that Ms. Lansing talked to you about is she talked about circumstantial evidence. She told you that the circumstantial evidence instruction gives the benefit of the doubt to the defendant, and that is true as to the first part of the instruction. Let me read to you the paragraph that I'm going to be discussing now. If the evidence as to any such specific intent is susceptible of two reasonable interpretations, one of which points to the existence of the specific intent and the other to the absence of the specific intent, you must adopt that interpretation which points to the absence of the specific intent. That means you're supposed to give the benefit of the doubt to the defendant. If, on the other hand, one interpretation of the evidence as to such specific intent appears to be reasonable and the other interpretation appears to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. So what that means is just because there are two interpretations, you're not supposed to abandon your common sense. You're supposed to use your common sense in evaluating the evidence. And if your common sense dictates that one version is reasonable and one is unreasonable, then you adopt that which is reasonable, even if the reasonable one points away from the defendant's version. Now, I have made a chart that is very simplistic, but I think that it's something that needs to be discussed because I think it's a very easy way to explain this concept of how you use circumstantial evidence. Okay, the question that's posed by this particular chart is, what is the thing that's being described by these four bits of evidence? From the evidence in this hypothetical trial, we find out that the thing we're talking about is 10 feet tall. Well, there are several things that are 10 feet tall. A tree can be 10 feet tall, a building can be 10 feet tall, and an elephant can be 10 feet tall. Let's assume for this hypothetical that the people are trying to prove an elephant. So the interpretation favoring the people for this particular fact that it's 10 feet tall is the elephant. An interpretation which leads away from the people would be a tree. So under the defense analysis, you would have to adopt that this is a tree, all right? Next, it's gray in color. The winter sky is gray in color, a mouse is gray in color, and an elephant is gray in color. Under the defense interpretation of how you use circumstantial evidence, I'm trying to prove it's an elephant, they're trying to prove it's not an elephant, therefore you would adopt let's say either that it's a mouse or the winter sky. Under the third piece of evidence, this thing has a trunk. An elephant has a trunk, a set of luggage has a trunk, or a car has a trunk. Again, under the defense interpretation, this fact would have to be interpreted away from the elephant and to the car or the set of luggage. Lastly, the last fact is it has large ears. A basset hound has large ears. B, an elephant has large ears. And C, a rabbit has large ears. Again, under the defense rationale, you would have to find that this is anything but an elephant. Of course, the problem with that is that I've told you that there's a second part to the circumstantial evidence instruction, and that is that you use your reason. Well, what thing of all these interpretations is 10 feet tall, is gray in color, has a trunk, and has large ears? It has to be an elephant. There is no other reasonable interpretation of these four facts. So, when the defense attorney tells you that you always have to adopt that which favors the defense, that's only if it's reasonable. And in this particular case, the version that it's a building, a mouse, a set of luggage, or a basset hound, you put those together and you get nothing. So keep in mind that when you talk about circumstantial evidence, you also talk about common sense. One thing I'd like to point out about this case is these particular defendants had never been put in the hospital due to a beating by their parents. They had never been threatened. If in fact Mr. Menendez, who appears to have had a Latin temper, told people that he was going to kill them, he never threatened them with a weapon. He never threatened his sons with a weapon. They were never put in a life-threatening situation. They were never put in a situation where they'd been placed in the hospital due to beatings, as many people are. And so when they talk about the honest belief in the need of self-defense, there had never been a situation which had ever put them into the state where they would reasonably and honestly have believed that they needed to use self-defense. And so it seems to me that to equate their situation with people who have been placed in that situation, battered wives and battered children, who have been hospitalized, who have been severely beaten and burned and bruised, is again an insult to all those people who survived and went on to lead productive lives. Mr. Burt challenged the prosecution to elect a time when the conspiracy was formed, and the conspiracy was definitely in place, and we don't know exactly when they agreed, because the defendants aren't going to admit to you that they conspired to kill their parents in a premeditated way, but certainly when they went to San Diego to purchase the shotguns, by then things were firmly in motion. Now, the defense attorneys are going to ask you, and they have asked you, to return a conviction of involuntary manslaughter. Let me give you an example of what an involuntary manslaughter is. Involuntary manslaughter is you get mad at someone and you shove them. You shouldn't have shoved them. It's unlawful to shove someone. It's called an assault. And that person falls down, and because of fate, they hit their head on a rock or the curb, and they hit their head and they pass out and they bleed to death. That is an involuntary manslaughter, ladies and gentlemen. The person who did the shoving had no intent to kill at all. The person who shoved was wrong for shoving, but that is a classic case of involuntary manslaughter. There are certain things, you've got to look at this case from the point of view of what the defendants were faced with at the time of their arrest and were faced with at the time that this case started trial. There are certain things that the defendants cannot explain away and have not explained away during the defense argument. They have not explained away Eric Menendez's very detailed description to you of what happened at the Big Five in Santa Monica. Now, the defense tried to confuse the issue. They brought in photographs. They cast doubt upon whether it was really the Big Five store, but they haven't explained it away. They cannot explain it away. It is something that will not go away. They cannot explain away Mark Heffernan when he said, I gave a tennis lesson to Eric Menendez on August the 18th, and I know my best guess it's the 18th is because Eric said we're going on a fishing trip tomorrow. There was never any evidence in this case that the fishing trip was scheduled for any other day but Saturday. And so Mr. Heffernan cannot be explained away by the defense. Ms. Lansing did not even address, and I don't believe Mr. Burt did either, the alibi route, what I call the alibi route, where the defendants went after the murders. Now, another fact that supports the people's theory that they bought the tickets for the movie before they killed their parents is under the defendant's versions of what they did during their alibi route. They would have gone to the movie theater with blood all over their clothes. Now, we know that Lyle Menendez had the presence of mind to think about fingerprints on the shotgun shells. He would have had the presence of mind to notice, hey, we're going up to buy movie tickets with blood all over us. So another fact which supports the fact that they did buy these movie tickets beforehand is the fact that they couldn't have gone up to buy those tickets with blood all over them. It would have been far too risky. The defense makes a lot of fun of Mr. Walker, and I'll talk about him a little bit more towards the end. But Mr. Walker and Mrs. Valdry, the woman who came in who said, yeah, he's been working on my pool on Saturdays, except for at the beginning when he was trying to regulate the chemicals. How do you explain, was Mrs. Valdry lying? Are all the people's witnesses lying? I mean, I didn't stand up here and tell you in my statement that all the defense witnesses are lying. I'm not going to tell you that this was a wonderful Ozzie and Harriet family where everybody was happy. Obviously, there were things wrong with the family. Obviously, these were not ideal parents. But the picture that's been portrayed by the defense is warped. It is slanted. It is there to get a result. And the result is to convince you that these murders were justified. And even if you don't believe that the defendants were acting in fear, again, the defense is trying to convince you that this, in fact, is a murder where you shouldn't care that the parents are dead. Going back to the law, again, murder is defined as the killing of a human being. Now, that seems to a fairly simple element to show, but I think what the real defense is in this case is this. NHI. Now you may all wonder what NHI is. NHI is a term used by jaded prosecutors and homicide detectives to describe a murder in which no human being is involved. So for instance, if you're a deputy district attorney and the police come in with a case and let's say a drug dealer is killed, the police officer will say, I've got an NHI murder here. No human involved. It is a sick kind of joke, but nonetheless, it's something that's used. And that is what the defense in this case is. It's NHI, no human involved. And really what the defense is saying to you subliminally is that Mary Louise Menendez and Jose Menendez were such horrible people that even though you couldn't possibly believe the events between August the 15th and August the 20th, it's okay because who cares if they're dead? The world is probably a better place without them. Well, one of the problems the defense has in this case is Mom. What about Mrs. Menendez? The defense is trying to portray her as well, at times they referred to her as a victim yesterday. When you read her letters that she wrote to her husband, and I'm not going to read them again, but I urge you to read the letters she wrote to her husband. And I urge you to think about what Dr. Conti said about what a horrible, selfish, awful woman she was. Read those letters and you will get a picture of the pain that she had, and you will get a picture of her humanity. This is a woman who loved her husband very much in spite of the horrible things he'd done. This is a woman who loved her children. She refers to her children as her gift to her husband. And this is a woman who the defense wants you to believe knew that her husband was having sex with his sons. When you read those letters, how can you reconcile the defense's allegations with the compassion and the humanity of the woman in those exhibits? This is Mary Louise Menendez before she became Mrs. Menendez. This is when she was Mary Anderson, Kitty Anderson. And this is Mrs. Menendez after she married Mr. Menendez and bore his two monsters. This is her before and this is her after. And the problem for the defendants in this case is they can't explain adequately killing Mom. They just can't do it. This is a horrific crime. Dr. Burgess talks about the fact that overkill was involved. Well, the problem was Mom wouldn't die. Mom was sneaking away. And the defendants were afraid that she was going to live. And if she lived, all their plans would be thwarted. Because if Mom lived, she inherited. If Mom lived, she could turn them in. If Mom lived, there would still be that person in their life who would keep them from doing what they wanted to do with their lives. The defense complains about the fact that the people use these photographs, but it seems to me that this photograph is far more relevant than a photograph of a stuffed animal. What we're here to discuss in this case is August the 20th of 1989, not whether Lyle Menendez had 15 or 16 or 17 stuffed animals. And this is the woman, this is this horrible, vicious, awful woman who the defense has portrayed as a monster. And when you read her letters, you'll see that she's not. This is the problem the defense has. They can't explain this away. Miss Lansing said I didn't talk about her much in opening. That's right, because I knew I was going to talk about her in closing. So the defense can't explain her away. They try to show her as Dad and Mom were a cohesive unit. Right. Dad and Mom were real cohesive. She tried to commit suicide in November, I think, of 86 or 87. And one of the letters you're going to read is 10 days later, and her husband's out having a drink at 11:30 at night. He took her to the hospital when she had her overdose, but 10 days later, he's still coming home late from work. He's still making her nervous. He's still giving her the same excuses he gave her when he was out with his girlfriend. So Mom and Dad as this cohesive unit is a ridiculous notion. That didn't happen. This woman was still a victim of her husband and a victim of her children. And can you imagine? This is the woman who gave her life for her husband. She allowed him to do what he wanted to do. She gave him the freedom that she thought he needed. She drove his sons hither and yon from lesson to lesson. She did their homework. She was a slave to everyone. And in the end, it took all those rounds to kill her. In the end, she didn't want to die. In the end, she wanted to live. The defense can't explain away Mark Slotkin and his discussion in front of you about the $5 million that the defense thought they were going to get. The defense can't explain away the Rolex watch 4 days after the slaughter. They can't explain away the 2 condominiums which Lyle Menendez purchased, one of them at or about the time that he got his first payment from the life insurance policy. They can't explain away the Porsche, and they can't explain away the restaurant. Now, Jamie Pizarsa got a $12,000 car from Lyle Menendez. Well, he had a $70,000 car. And things are all relative. You hear about sports stars who give $1 million to charity, and you think, wow, that's a lot of money. But if the sports star made $200 million that year, it's not such a big deal. Likewise, if Lyle Menendez had been driving a Honda Accord instead of a Porsche, then proportionately, Jamie would have gotten a very nice bicycle. The defense can't explain away the computer erasure. They can't explain away Howard Witkin. Now, they can't tell you that Howard Witkin's a liar. I mean, I don't know how anybody could stand up here with a straight face and tell a jury that Mr. Witkin is a liar. So Lyle Menendez has this very elaborate story about how he wanted to trick his Carlos to see if Carlos was up to no good. But that is utterly and completely ridiculous. They can't explain away the fact that Lyle Menendez flew out specially one day to get at that computer, because even though Carlos Baralt, the non-lawyer executor of the estate, felt that a will and a computer would not be any good, Lyle Menendez couldn't take that risk. The family had found the wills that left the estate to the men, not the boys, the men. And Lyle Menendez had to make sure that there was no codicil, which is an addition to a will. He had to make sure there was nothing in that computer which would thwart he and his brother getting the estate. The other thing the defense can't explain away, and neither can their experts, is this notion that after acting in fear and slaughtering their parents, and even in this automatic state, reloading the gun for one last shot at mom, how all of a sudden they snapped out of it, discussed, what are we going to do now? Well, let's go to the theater, let's get rid of the guns, let's get rid of the shotgun shells, let's get going. How did they switch from this automatic state where they didn't know what they were doing and miraculously only 2 rounds missed? How did they go from that state where they just were in a daze to the state where they were able to coolly and rationally figure out how to get themselves out of the mess? How did they go to the police department at 1:42 a.m. and start line and line and line? Now, remember, Mr. Fenno said that the defendants were very good at telling detailed lies to their parents, so they obviously had had practice. But if Dr. Burgess is to be believed, somehow something occurred that snapped them out of it and started their thought processes at full tilt. And they were able to think up all these things and execute all these things in the miraculous time of 67 minutes, which we've proved to you could not have happened. They cannot explain away the December 11th tape. On that tape, which I urge you to listen to and follow along with the transcript, you will hear Lyle Menendez talking about planning to kill his parents. Now, Ms. Lansing tries to use the tape, as a good attorney would, to the benefit of the defense. I mean, when you have lemons, you make lemonade. And in this particular case, she tries to say that the December 11th tape shows that Dr. Oziel is a liar because there are certain things that are not contained in the December 11th tape. For instance, certain of the things that Dr. Oziel testified to are not made in the December 11th tape. But remember, Dr. Oziel testified that he had offered his services to Lyle Menendez in case he ever got caught, to try to explain the family constellation to help the defendants. And that is what the December 11th tape is. And remember the testimony, I can't tell you which part to remember and believe, but of Judalyn Smith. Judalyn Smith, in spite of her harebrained ways, corroborated Dr. Oziel in many respects. And some of the tapes that you'll have available to you of her various phone conversations with Dr. Oziel corroborate the fact of what occurred during that period of time. But the December 11th tape has Lyle Menendez in his own voice, coolly and calmly, not in an automaton state, not acting like a snail, not responding to his limbic system. Lyle Menendez is there talking about planning to kill his parents. It's as plain as day. Now, the defense says the prosecution has abandoned Dr. Oziel because his credibility was so thoroughly shattered. Well, ladies and gentlemen, let's assume, and I'm not saying we have abandoned Dr. Oziel, but let's say Dr. Oziel is the biggest liar in the world. And I'm not saying he is, But even if he were, the defense hasn't proved he can't work a tape recorder. And once that tape came in, all the attacks on Dr. Oziel seem a little silly, because basically you will hear in his own voice Lyle Menendez talk about planning to kill his parents. Now, those words, planning to kill, are nowhere in Dr. Oziel's lengthy talks with the defendants on the December 11th tape. The defense wants you to believe that just as they keep saying the boys, the boys, the boys, Dr. Oziel kept saying the plan, the plan, the plan. Remember, Dr. Burgess said that at one point on this tape, he used the word control 15 or 19 or some such number of times. And that was to indicate to you that he was repeating the words to brainwash the defendants. Well, I challenge you to listen to Dr. Oziel talk about the plan to kill mom. On that tape, there's nowhere where Dr. Oziel analogizes killing mom to getting rid of the dog. On that tape, also, interestingly, is Lyle Menendez's description of how much money his father earned and the fact that his mother had no knowledge of the $5 million policy. There's nothing on that tape where Dr. Oziel's telling him to say that. This tape was made by the defendant to help him later on. But of course, the facts contained in that tape are not good enough. This defendant concocted his defense. He made it up. Now, why should you believe Lyle Menendez? Lyle Menendez is an admitted liar. He lied and lied and lied in order to keep himself from being caught. Why wouldn't he lie in order to keep himself from being convicted? The stakes are much higher now. Before, the idea of being caught was something that always was nipping at his heels, but it was never real. It never happened until March of 1990. Now it's real. Now it's happened. Now he's got plenty of time and all the motivation in the world to lie to you. And the defense has not given you one good reason why you should believe him. And as a matter of fact, as to the events of August 15th through August 20th, we have proved that much of what the defense says happened did not happen. And the defense can't get away from that. Now, they try to muddy the waters. They try to explain it away. They try to give you let's just give you more photographs of the Big Five, and maybe somehow you'll get confused. But they can't explain that away. Miss Lansing made mention many times of the fact that Lyle Menendez admitted things to you. Therefore, you should find, well, he didn't have to admit that. Well, ladies and gentlemen, let's look at it from the point of view of the defendant. He had to admit that he bought the shotguns in San Diego. Let's assume Lyle Menendez had denied it. Let's assume he and his brother had denied it. What would the evidence have shown? The evidence would have shown that someone using Donovan Goudreau's driver's license, and you're going to see the picture of Mr. Goudreau on the driver's license, and the driver's license number in the picture of his license matches the driver's license number on the shotgun purchase records. So we know that was the license presented. Someone named Donovan Goudreau signed that form on August the 18th and bought 2 shotguns. Somebody killed Mr. and Mrs. Menendez using 2 shotguns, most likely. It could have been 1, but most likely from the number of rounds fired and from what the neighbors heard, 2 shotguns. Donovan Goudreau was Lyle Menendez's roommate in college. Can you imagine what you would have thought of that if he hadn't admitted it? And Wesley Gross came in and said, I can't make the handwriting positively, but between Donovan Goudreau, Eric Menendez, and Lyle Menendez, the handwriting most closely resembles Eric Menendez. Well, that's good enough, ladies and gentlemen. Can you imagine what we would have thought of the Menendez brothers if they said, we didn't buy the shotguns? They had to admit it. They had to admit it in order to sell their story to you. The reloading. He admitted he reloaded. Well, in spite of what Ms. Lansing says, in spite of Mr. Burt's, I have no idea why he brought up the number of pellets to you. I think he said there were 56 pellets recovered. Well, we know the 56 pellets, I think it was 23 or 27 rounds of buckshot, or 27 pieces of buckshot per round. If there are 56 pellets, all that proves is that 2 rounds plus were fired. But we know from Deputy Van Horn that at least 8 rounds were fired, and we know from the crime scene that more rounds than that were fired. So the defendant had to admit reloading. Can you imagine if he hadn't admitted he reloaded? After Mrs. Lord and Miss Crome came in and said that they heard a pause, after we were able to show you that some rounds were birdshot and some rounds were buckshot, after we were able to show you the number of rounds which were fired, if they had come in and denied the reloading, can you imagine how bad that would have looked for them? They have to admit it. Now, Ms. Lansing makes much of the fact that Lyle Menendez took responsibility for the contact wound to his mother and to his father. Well, we proved to you that there was a contact wound on the mother and a contact wound on the father. Can you imagine what you would have thought if these defendants had broken ranks and started pointing at each other? Hey, I didn't do that. No, I didn't do it either. Can you imagine what you would have thought of the defense if they broke ranks and they started pointing the finger at each other? They had to admit that. They had to admit they'd been to the movie theater. See, that's the big problem with this alibi route, you see. They have to admit, we know they got rid of the shells because the crime scene has no shells. They've got to admit it because what else can they say? We know they took the guns from the crime scene because the police were there shortly after they called. There were no shotguns there. They had to admit that too. So they had to admit getting rid of the shells. They had to admit getting rid of the guns. And they had to admit going to the movie theater because they had information that they only could have had if they'd gone to the theater, which was License to Kill was sold out. Now you have the TV listings of when those movies ran that night. And everyone knows when you go to the movies, there's at least 10 to 15 and maybe 20 minutes of previews before the actual movie starts. And we've stipulated as to how long each movie was, and they're approximately, one movie is about 7 minutes longer than the other, but they started at different times. And based upon what the defendants told you, do you really think that when he went to the movie theater, that License to Kill was still playing and that the clerk would have said, oh, that movie is sold out for the 8 o'clock performance? By the time they got to the theater, License to Kill was over. And the reason they knew it was sold out is because they went to the movie theater before they slaughtered their parents. But you see, once they told the police that they knew License to Kill was sold out, they had to admit to you that they'd gone to the movie theater. Because can you imagine what you would have thought of them if they'd taken the stand and said, no, we never went to the movie theater. And then the prosecutor says, well, then how did you know License to Kill was sold out? There was no way for them to find out unless they'd been to the movie theater. So they had to admit that. Of course, by admitting it, it really messes up their alibi route after because there's not enough time to do everything they said they did. The defense has to admit that they called Perry Berman, that Lyle Menendez called Perry Berman. I mean, can you imagine if they came in here and said Perry Berman was a liar? No, we never called him, we never made plans with him. Because we have the phone records on Mr. Menendez's U.S. Sprint card, which shows a phone call from the Santa Monica Civic where Taste of LA was playing. Remember, Lyle and Eric told Sergeant Edmonds, we went to Taste of LA. We have the phone record there. Can you imagine what would have happened in trial once they got caught? If they'd come in and said, Perry Berman? Who's Perry Berman? I mean, they could do that. They had to admit it. They had to have changed their clothes sometime during that night because we know from Dr. Burgess that they got blood on them. Common sense tells you they got blood on them. But we know when they went to see the police, they weren't that dumb. They weren't going to go with blood on them. So that's another thing that they have to admit, that they changed clothes, because otherwise you wouldn't have believed anything out of their mouths. The defendant is stuck with the fact that he went shopping after he killed his father. He's stuck with the watch. He's stuck with the Rolex. He's stuck with the Porsche and the restaurant and the condominiums. I thought it was interesting that Ms. Lansing tried to impeach Richard Wenskowski with the fact that he didn't remember or didn't admit going to a nudie bar when he was in Los Angeles. Now, I don't know that much about what kind of entertainment Mr. Wenskowski likes. It could be that he goes to a lot of them and one is as good as another. I don't know. But they want you to believe that he's a liar because of that. And yet Lyle Menendez admitted he bought the Porsche. He admitted he hired the bodyguard. He admitted all those things. So what is it Mr. Wenskowski's lying about? Why is it that all the prosecution witnesses that they don't like are liars? Why is that? Doesn't that seem a little perplexing in light of the fact that the history of lies belongs to the defendants? Lyle Menendez is stuck with a computer erasure. I mean, as I said earlier, they can't say Mr. Wicken's a liar. I mean, that would just be stretching credulity. Nobody could say that. Lyle Menendez is stuck with the bribe offer to Jamie Pozarczyk. He's stuck with it. He had to admit it. And they're stuck with the fact that they lied to everyone, especially their family. Now, can you imagine if they came in and said, we never lied to anyone? Well, then we have the reporters they lied to, their family members, who they were relying on these family members to come in and try to bail them out. But they lied to their family members. And so in order to give their family members credibility so the family members wouldn't hurt them too much, they had to admit, yeah, we lied to our family. They're also stuck with their voices on the December 11th tape. They're stuck with that. They cannot get away with that. And they have to admit, well, those are their voices. So what do? They call in Dr. Burgess, the woman who is an expert in snails. She's an expert in critiquing other therapists. She's an expert in nursing. She's an expert in crime scene reconstruction. And I'll bet you if needlepoint were in this trial, if somebody had been needle pointing, she would be an expert on needle pointing too. She was an expert on anything you needed in this case. And she comes in and she says, well, one other thing I'm really good at is therapy. And look at what a crummy therapist Dr. Oziel is. Let me show you all the ways he messed up on this tape. It's like, time out, lady. This tape is not about Dr. Oziel. This is not a malpractice trial. We're not here to get money damages against Dr. Oziel. Let's talk about what the defendant said. And she said, I can't see anything wrong with that. Well, I say to you, ladies and gentlemen, there is none so blind as she who will not see. And in light of overwhelming, obvious, reasonable evidence, all she did is focus on the malpractice trial of Dr. Oziel. And you know what? Dr. Oziel is the most maligned person in this case. Because whatever you think of Dr. Burgess, if you listen to what he was trying to do with these defendants, and she said it was wrong for him to have them hug each other. Why? He was trying to help these people. He was trying to help these people. He was trying to help himself. Whatever you think about his extramarital affairs, the man is not indecent. He did not extort these defendants. He didn't turn them in. He was trying to help them. He was trying to save his life. He was trying to strike a balance between being a therapist and being a potential victim. And even if you don't buy that and you don't like Dr. Oziel, you can't deny the fact that it doesn't take a lot of talent to turn on a tape recorder. And the defense can't explain that one away, in spite of Dr. Burgess and her pickiness and her focus on Dr. Oziel's bad acts. I mean, after all, Dr. Oziel may have had a mistress, but he's got no dead bodies in his wake. And I'm sure the defense isn't going to argue that Dr. Oziel convinced these defendants to kill their parents so he could use that fact to control his girlfriend. I mean, that seems to be the next logical step. Somehow Dr. Oziel made this big mess in order to control his wife and his girlfriend. Dr. Oziel is not the bad guy in this case. The bad guy is sitting right there. Dr. Burgess talked about the crime scene, and she talked about how imperfect it was, and I've talked about this in my opening statement. But she ignored the fact that they removed the shells. She ignored the fact that they removed the weapons. And she ignored the fact that there was no physical evidence of identity left at the scene. See, the beauty of doing the crime in the home is that any fingerprints or their presence in the house at all could be easily explained. They live at the house. But let me say something else about them living at the house. These two men were of age. Let's say that Mr. and Mrs. Menendez had thrown them out and said, that's it, I'm tired of it, you're out of here. These defendants had no right to live in that house. It was not their house, it was their parents' house. And there are many people whose parents say, when you turn 18, you're out of here. And those people have no right to come after their parents for support or a home or anything else. So although this was their home, it was really their parents' home. And their parents were continuing to support them in their lifestyle, support them while they screwed up, support them while they were spoiled, vicious brats. Now, I'm not going to tell you that these defendants didn't have some unhappiness in their life. It's very clear they did. And let me talk to you a little bit about the experts. The experts came in and they talked about child abuse. Well, if you believe the defendants, they were abused. And you don't need an expert to tell you that. If you believe what the defendants told you about what happened to them, they were abused. And the idea that violence begets violence, in other words, if your parents beat you, then you will learn how to beat other people. You don't need an expert to tell you that. Common sense and your life experience. And just look at society. You know that's true. You see, the thing about the experts is the experts based their entire discussion on their belief in what the defendants told them. But again, the experts closed their eyes to the truth. They closed their eyes to the impossibility of what happened between August the 15th and August the 20th. So the defense says, well, the prosecution didn't call any experts. Well, we can't put on an expert to say, I don't believe the defendants. That's not permissible. It came out in cross-examination when I was cross-examining the experts, because that's the basis of everything they're saying. But the prosecution can't put on an expert to say, I don't think the defendants are telling the truth. The principles about child abuse are correct. There are no set things that tell you that a child has been abused. Child abuse has all different kinds of results. Some kids get abused and they do fine. Some kids get a little bit abused and they do hideously. That's what Dr. Briere said. He was right. That's true. So there's no reason to bring in an expert to say, yeah, that's right. That's exactly what happens. Because you see what the defense has done, the defendant has done, is he's tailored his defense in order to meet all of the requirements of the experts. So the issue is not what do the experts say, it's whether or not you believe the defendant. And if you believe the defendant, then he was abused. And if you don't believe the defendant and you don't believe his brother about the sexual abuse, then they weren't abused. And you know what? It doesn't matter, because we know and we have proved to you in this courtroom that the defendants lied about many of the things that form the underpinning of the events of August the 15th through August the 20th. And do you really think that child abuse justifies murder? That they did not act out of fear. They premeditated. And whether they were abused or not, the abuse would provide, in my opinion, motive to kill. Not all abused kids love their parents. Some abused kids hate their parents. Kitty Menendez was prone to rages. She had a temper. It appears that Jose Menendez had a temper too. It appears these people got angry. Why wouldn't their children be angry too? I mean, you learn behavior from your parents. Why is it they won't say that they're angry? They're not angry, they're not angry. Well, they can't admit they're angry, because if they're angry, that gives them a motive for killing their parents in a premeditated way. One thing I'd like to note about Dr. Burgess, and she came in here and she gave this critique. After everything she's told you, think about if there was somebody that you really disliked and you wanted to murder them. Think about planning out a murder, and think about all the contingencies, because you want to do it perfectly and you don't want to get caught. And you know what? It's really difficult to do, because you can never predict how your victim's going to behave. You can't predict the weather. You can't predict if someone might drive by at the wrong time. You can't predict what's going to happen. There are so many contingencies in this kind of plan that you can't account for all of them. Dr. Burgess would have you believe that anybody who gets caught couldn't have premeditated, because if they premeditated, they would have done it perfectly and therefore couldn't have gotten caught. And that is a ridiculous notion, but that's basically what she's saying. That if you got caught, you were a poor planner, which means you didn't plan at all. And that is not true. That is a total abuse of words. One thing I'd like to note about Dr. Oziel. Remember, Dr. Oziel is the one that talked to the defendants on November the 2nd about starting this defense. This defense of abuse, this defense was actually started by Dr. Oziel. He's the one that said, if you get caught, I can help you with your family constellation to explain why you did what you did. So this is something that was planted long before the defendants were even caught. The testimony of the coroner, I went through that already, but let me just say one thing. If you look at the photographs, of the crime scene, there's something on the couch here. It's a remote control for a television. Mr. Menendez got shot in his left elbow. The remote control is right next to where his left elbow would have been. In addition, we've shown you that there was a TV guide open to the evening listings for the television. And if you look at his legs, and you can't see them in this photograph, but you'll see them in others. If you look at his feet are crossed, and the sides of his feet are resting on the ground. And I'd like you to look at those photographs and ask yourself, what was he really doing at the time that he was shot? Now, the defense, I think, has him in a preposterous position. They have him with his arms up like this and his leg extended so that all these shots could have been fired to him. And maybe he was hopping around the room to get these particular shots. That's not a reasonable explanation of how this happened. And remember, if circumstantial evidence, one is reasonable and one is not reasonable, you adopt that which is reasonable, even if it's detrimental to the defense. I'm not going to go through all the witnesses again, but I'd just like to point out to you the following things. In the summer of 1975, Alan Anderson stayed with the Menendezes. In the summer of 1976, Kathy Simonton and Diane Vandermolen stayed with the Menendezes. In the summer of 1977, Alan Anderson stayed with the Menendezes. Between June 1st and September 21st of 1978, Diane Vandermolen stayed with the Menendezes. For 2 weeks in 1979, Diane Vandermolen stayed with the Menendezes. From June of 82 until July of 83, Diane Vandermolen stayed with the Menendezes. In July of 86, Mary Ann Cano stayed with the Menendezes. And between November of 88 and March of 89, Ed Fenno stayed with the Menendezes. What child molester invites strangers into his home to catch him child molesting? I mean, it doesn't make any sense. Lyle Menendez testified that when he was 13 years old, he heard noises behind closed doors, which led him to believe that his brother was being abused. Why did these people, all these people who stayed during the summers, why didn't they describe the noises that Lyle Menendez said he heard? Ladies and gentlemen, sex has a distinctive sound, and I don't know if this has happened to any of you, but sometimes you can tell what's going on behind closed doors just by the sound of what's going on. Why didn't any of these people hear any of that? Ms. Lansing talked about Perry Berman and that he really isn't an alibi. Well, Perry Berman couldn't have been with him at the exact time of the shootings because that would, of course, be a witness. Perry Berman was part 2 of the alibi. Part 1 of the alibi was going to the movies. And remember, the defendants had seen both Batman and License to Kill before they went to the theater that night, so that if they were asked, well, what was the plot, they would be able to relate that plot. That shows signs of premeditation. Perry Berman was for the second half. In other words, we were at the movies, and then here's a live person who can say that we were with him, and we couldn't, and we know what happened in the movie theater. One was sold out, and we know the plot of the movie we saw, and now we're with Perry Berman. Our time is covered. They couldn't have been with Perry Berman at the time of the shootings, but they could be with him shortly thereafter. And the reason Lyle Menendez called him back is because Perry Berman was supposed to be with them when they discovered their parents, so that Perry Berman could be a witness to their shock and dismay at this discovery. Perry Berman, of course, was acting decently and said, hey, I don't want to wake up your parents. I mean, Mr. Menendez was supposed to help him get a job in a couple of weeks. So Perry Berman said, no, I don't want to do that. I'll meet you at the Cheesecake Factory. So the defendants were on their own. But this point about him not being an alibi witness is incorrect. I'd like to talk to you about some photographs. First of all, this particular photograph, which is Exhibit 194, is a photograph of Lyle Menendez in the backseat of a car. And I think Lyle Menendez testified that he was purposely looking sad, that he trained himself to look sad when he lost because that's what his father expected. Remember, Lyle Menendez said that his father taught him to be the master of his emotions. He indicated that he purposely looked sad when he lost because that's what was expected. This is an actor in training, ladies and gentlemen. Now, here's the photograph that the defense is pinning their hopes on. It's Exhibit 232. This is one of the two. Look at this particular photograph and ask yourself, how tall was the person who took the picture of his brother in this photograph? On the same roll, you will see another photograph of the dishwasher. You see? And look at the height of the person who took this particular photograph. I suppose Mr. Menendez could have been stooped down when he took a picture of his dishwasher and his son. But look at these two photographs and ask yourself, if Mrs. Menendez was so concerned about public image, and if Mrs. Menendez knew her husband was a child molester, why did she package up these photos and label them as Eric's 6th birthday party? Who took these photographs, ladies and gentlemen? It's very easy for the defendants to say their father took them. He's not here to say he didn't. But if you look at the photographs and you look at the roll and look at the complete roll, how tall is the person who took these two photographs? One of the things that Ms. Lansing told you about was that it was her theory that what caused the great change in the relationship between Mr. Menendez and Mrs. Menendez was that Mrs. Menendez was blackmailing Mr. Menendez. That she had said to him, this is just her theory, Jose, I know you're a child molester, and if you don't stay with me, I'm going to tell everyone. Well, first of all, what really happened is Mrs. Menendez tried to commit suicide, and I don't understand how that can be ignored. You have Exhibit 336, which are the hospital records of her going to the hospital. You'll see in there that she took an overdose of her medication. You'll see in there that she also tried to take more medication at the hospital. This woman was very distressed. And whether she really intended to kill herself or to scare the heck out of her husband, it seems to have had its effect. So when Ms. Lansing says there's no evidence to show what changed the relationship, this is an exhibit offered by the defense. It's Kitty Menendez's hospital records. And it seems to me that if Mr. Menendez was this murderous, horrible person, this person who would kill everyone in his family, if Kitty Menendez was blackmailing him and she was suicidal and she was taking drugs, how hard would it have been for him to slip her a few extra? I mean, if he was really this horrible person who would do that kind of thing, her suicide, she's got one suicide attempt on the books. They have medical records of it. If she was blackmailing him, all he'd have to do is give her a few extra Xanax and that would be it. No, this man actually took her to the hospital when she attempted suicide. According to Marzi Eisenberg, he didn't love her anymore, but he was very concerned about her. He didn't want his wife. He didn't want the mother of his children to die. So this is not a man who's a homicidal maniac. This is a man, he's 45 years old. He's making a lot of money. He's extremely successful. His wife is suicidal. She's depressed, probably getting to be menopausal, and he was concerned about her. So this notion that she was blackmailing him with this dirty secret, you read the letters that she wrote. You read the letters that she wrote, and then you ask yourself, did this woman know that her husband was molesting her sons? Terry Beralt and Carlos Beralt, I mentioned, yes, I think that they were the most credible of the witnesses who talked about the family constellation. But keep in mind, they may have been frequent observers of the Menendez family, but they were not the most recent observers. You see, they lived with the Menendezes on the East Coast, and when the Menendezes moved to California, they no longer were in constant everyday contact, and yet they noticed the change in the relationship between Mr. Menendez and Mrs. Menendez. Well, who knew the family socially out here? Who saw Mrs. Menendez quite frequently? It was Karen Farrell. Now, the defense wants you to believe that people can't change or people can't try to change. So Karen Farrell says that she saw Mr. and Mrs. Menendez hug their children. Well, Lyle Menendez, Eric Menendez, and Mrs. Menendez had all been to a therapist. And on occasion, Mr. Menendez had gone to a therapist with Mrs. Menendez. If, in fact, they were hugging their children, maybe that was part of this new game plan to try to make the family more cohesive. So when Karen Farrell says she saw them hugging, it is clear that there was a change in the relationship, that Mr. Menendez was trying harder in California to be pleasant to his wife than he was on the East Coast. Ms. Lansing showed you some blue pieces of paper that had evidence, testimony on them. And one of the things she did is she took these letters that you're going to be looking at, and she talked about the fact that Kitty Menendez talked about her father, and the next thing she did is she talked about sex. Well, clearly she wants you to believe that Mrs. Menendez was sexually abused by her father. That is an outrageous notion. But let's talk about something for which there is more evidence. Let's talk about Eric Menendez. Mrs. Menendez, according to Eric Menendez, Mrs. Menendez wanted him very badly to get a girlfriend. Mrs. Menendez was worried about his sexuality. Eric Menendez testified that he was concerned about his sexuality, and Eric Menendez indicated his father called him a faggot. Now, Eric Menendez admitted that his father had disowned him, but he said the reason his father had disowned him is because he wasn't opening up in tennis. So if you want to draw inferences about people's sexuality, let's look at the evidence in the case. What was it? Who were the friends that Eric Menendez referred to in the December 11th tape, the friends that he couldn't tell his mother about? What was the family's secret in this case? Look at the evidence and think about it. Was Mr. Menendez going to disown his son because he wasn't opening up in tennis? So rather than think about whether or not Mrs. Menendez had been molested by her father, look at the evidence in the case that talks about another secret in the family. Roger Smith, according to the defense, is a man who should be believed, but he is the man who spoke at the funeral of the man that he intensely disliked. It seems that Roger Smith is a man who will say whatever the occasion calls for, be it a funeral or a courtroom procedure. Mary Dominguez was the woman who helped Mrs. Menendez. She helped close up the Slotkin house and establish the Menendez house. And she talked about these magazines that she found, these gay magazines. And I'd like to ask you, in light of what I've just talked about, whose magazines were they? In this particular case, the victims have been put on trial. Dr. Oziel has been put on trial. Witnesses have been called to repeat the same themes over and over again so that the repetition will get into your brain and won't get out. One thing about repeating things, I'd like to point out that Dr. Conti was able to get up and recite the exact litany of things that happened to Lyle Menendez in his life, and he was able to recite the events of August 15th to August the 20th. Now, Dr. Conti, if he can do that with the amount of preparation he's had, can you imagine what Lyle Menendez can do with the amount of time and motivation he has to repeat those same facts? My point is that Dr. Conti could go through them fact by fact and tell you exactly who said what. He even gave you exact dialogue. Well, if Dr. Conti can do that, why couldn't Lyle Menendez? Grant Walker. Poor Mr. Walker. Mr. Walker was offended by what he heard. He was so offended he didn't want to say the words in court. And it's very hard to imagine that anyone couldn't have had a little compassion for this man who obviously wouldn't say a bad word if he had to. And the judge urged him and he wouldn't do it, and he didn't want to say these bad words. And this is this vicious, lying, horrible person who came in here for his 15 minutes of fame. Well, I guess really you have some choices with Mr. Walker. Either A, Mr. Walker is lying, he's not a pool man, he's a media hound. Or B, Mr. Walker is telling the truth, but he's got the wrong weekend. Or C, Grant Walker didn't really remember where he was when John Kennedy died. Or D, Grant Walker is telling the truth and the defendants are lying. Seems to me that D is the most likely possibility. Seems to me that Mrs. Valerie didn't come in here and lie to you about the day her pool man comes to clean her pool. I'm going to be done in 5 minutes.
5 minutes?
Yes.
Okay.
In conclusion, ladies and gentlemen, is it so hard to believe that rich people as well as poor people resort to violence? We live in a very violent world. We live in a world where most people can't even govern themselves without violence. In Yugoslavia, they're killing each other. In Somalia, they're killing each other. The Irish Republican Army continues to kill each other. And in Southern California, we slaughter each other all the time. Ms. Lansing told you, don't be prejudiced against rich people. And I say to you, that's right. Don't assume that just because people have money, they can't be violent. Violent is part of man's basic nature. If these defendants came from a poor background, if they came from South Central Los Angeles, you'd have no trouble believing them capable of violence. Why is it so hard to believe that these two people are capable of this kind of violence? And yet if they come from South Central Los Angeles, would they have had daddy's money to make up this defense? Look at these defendants, look at their crimes, look at what Lyle Menendez has tried to sell you as a defense. Look at the lies that he has told you on the witness stand and ask yourself, can you believe anything that this man says? There's no possible way. He is not acting like an adult. He wants you to believe he's a child, he's a boy, he's not responsible, he's a victim. He's an adult, he's responsible for his actions, he planned out this crime. And rather than taking whatever his background was, and I don't think we can be sure at all what his background was. You've been painted a picture here, but it's just a picture, it's not real. And you've been painted a picture here to convince you that Mary Louise and Jose Menendez are not worth your consideration. That the world is a better place for them having passed on, or died, or been slaughtered. But that's not correct. These people were cold-bloodedly slaughtered by their two sons. And whatever they had done to their sons during their lives, they didn't believe it. And look at their mother. This is the woman who gave birth to them. This is what they did to their mother. And I'd like to say one final thing. The man that I described to you in my opening remarks, the man who ran away from home, the man who would not go to his father's bedside, the man who made something of his life in spite of the abuse, that man was my father. Thank you.
All right, thank you. We'll take a recess. We'll resume at 1:45, ladies and gentlemen. If you would come back, and I'll instruct you at 1:45. Don't discuss the case with anyone. Don't form any final opinions about it. We'll have you back at 1:45.
All right, I want to just briefly discuss any last minute details regarding instructions, and we'll do that. We had not yet resolved one instruction, 2.10, statements made to a physician. And my view is that that should not be given at all, since it is a matter for the jury to decide as to how to treat that evidence. And I don't think it's the way the evidence has been introduced, it would be an appropriate instruction. So I will not give that. It was submitted in its unaltered form by the prosecution and in a modified form by the defense, and I will not give it either way. I've added a couple instructions to the packet. One of them is an expansion on implied malice or second-degree murder, the 8.31. The only other instruction about which I would make further inquiry is 8.80, the long paragraph that we had discussed before, the special circumstance instruction. The position of the defense and the prosecution was to delete that instruction in its entirety. Is it still your request?
Instruction of the paragraph.
That paragraph, I'm sorry, regarding intent.
I don't have it with me, Your Honor. Could the court, what's the first paragraph? Does it talk about intent to kill? Oh.
The defense made that instruction and included it. There was some reference in the argument that if it was a veiled reference to whether the defendant was the one who actually fired those last shots or not, regarding who had blood on pants, as to whether that was designed to refer to that in some way. That was by Ms. Lansing.
Situations?
No.
Well,
If on the lying in wait, there is a requirement of intent to kill. All right, it's been altered by the defense, I think, in the modification submitted. I think that's adequate for the purpose.
was the aiding and abetting in there? Because I don't think that's appropriate.
Yeah, I don't think we're going to define unless we want to add aiding and abetting here as a further definition to supplement the.
No, I think we would prefer to the form that we gave, without
Adding aiding and abetting in a
Without-
separate instruction, 6.00, 6.01.
Well, if you're going to give 8.00 with aiding and abetting, then I think we ought to give 6.00 and 6.01. And because of the defense argument, I think it might be a good idea.
6.00 is 10.
No, I'm sorry, 3.00 then.
We have no objection.
3.00 and 3.01. Okay. All right. Anything else now before the recess?
As to the verdict form,
Yes.
it's our position that the verdict forms as proposed by the court are incorrect in not providing the jury with verdict forms of not guilty for second-degree murder and not guilty as to all lesser included offenses. And looking at the use note to 17.49, which is the instruction on multiple verdict forms. And the use note indicates that if the court gives the Stone instruction 8.75, when that is done, the jury must be given guilty and not guilty verdict form for each greater and lesser crime.
Yes.
And then it says, however, if the Stone instruction, they say 1712, which is the Stone instruction, is not included in the original jury charge, then this instruction, accompanied by 1710, may be provided to the jury. Under this approach, the jury should be provided with one not guilty verdict and one guilty verdict as to each greater and lesser offense. And I think unless that's done, the jury has no option or no means by which to return a not guilty verdict, by which to decide a not guilty verdict as to a greater offense before returning it. And that would apply in a situation where they unanimously agree that murder in the first degree has not been proven. Under Stone, they have to be at least provided with the option of reaching that, even if they're not going to return that verdict. And I don't think the court's verdict form allows them to do that.
You misread that sentence. It says, under this approach, the jury should be provided with one not guilty verdict and one guilty verdict as to each greater and lesser offense. That's what it says.
Right.
One not guilty verdict, and that's what they're provided with. Not for one not guilty verdict for each greater and lesser offense. If it said that, it would have said it as it did in the first paragraph.
Well, I see the way the court's reading it. I'm reading as to each greater and lesser offense to modify both guilty verdict and
Yeah, if they meant that, they would have said it the same way they did in the previous paragraph. They wouldn't have had to say it twice. They would have presupposed that would have been given either way.
I just don't see how the jury then is provided the option of returning or agreeing on not guilty as to first degree murder or second degree murder under the court's.
They're told they only can return one verdict as to any count. That's it. So, and they're also told in 1710 that in order to return a verdict of guilty of a lesser offense, they must unanimously agree that the defendant is not guilty of the greater offense. So they're told that. They're not provided a verdict form for it because they're told they only can fill out one verdict form.
What happens in a situation where they agree that murder in the first degree and murder in the second degree is not committed? They sign the court's one not guilty verdict form. What happens to the manslaughter count?
Well, if they find them guilty of manslaughter, they're told they can only sign one verdict form as to any count. So if they follow that instruction, they will only fill out the verdict form of guilty for manslaughter or second degree murder, or for whatever it is. They'll only fill out one verdict form at all. And I go over that again when I finish the instructions. I go through the verdict forms and tell them only one verdict form can be signed as to any count.
And maybe I don't understand, but assuming they decide not guilty first degree and they sign the not guilty
They won't.
verdict form.
Well, unless they're finding him not
And now
guilty altogether, they won't sign any verdict form until they decide what he's guilty of. And then they sign the one verdict form, guilty or not guilty, one form.
But what I'm saying is during the course of the deliberations, assuming they get to the point where they say, okay, we agree that he's not guilty of first degree murder, there is no way for them to record that judgment. And now they go on to second degree murder and he's not guilty of second degree murder. And there's no way to sign that judgment.
Right.
And they just keep deliberating. And so if at some point they come back and they say, well, we can't reach a decision, we're hung on manslaughter.
Then I give them the
They-
instructions regarding the Stone case and the not guilty verdicts for the greater crimes, and they have an option of then filling those out. That's the procedure that's provided for in the Calgic instructions and contemplated in Stone.
It just seems that at the point that you give them those verdict forms, they sort of may reopen the discussion on something that at an earlier point in time they may have reached consensus on and been unable to document it.
Well, this is not a new or novel approach. This is, as I said before, something that is done regularly here in Los Angeles County. I know, Mr. Burt, you come from a different county with different procedures perhaps, but this is
I come
the
from
way we
LA
do
County.
it. I've
I've
done
always
this,
gotten guilty and not
well,
guilty.
I've always done it this way, and I've always seen it done this way as both judge and lawyer, so this is the way it's going to be done. All right, I'll supplement the instructions with 3.00 and 3.01. And if you want to look at the instructions in their version that will be given to the jury, they're available now for you to look at. Keep it in the same order.
When the court finishes with the instruction, is there any way I can make a copy for myself and the defense and then give them back to the court, or?
Yeah, sure.
Okay.
Well, you'd have to do it rather quickly, and
Yes.
what I don't want to do is, I'll have the clerk do it. She's already done it, but I've changed it since then, so rather than We'll have the clerk make copies for
All right,
council.
just one copy and then I'll make the register.
Okay. All right, if you want to look at them now, they're certainly there for you to look at. All right, in the trial, we now have the jurors present, and at this point, I will read to the jury the instructions. I'm not sure if we'll be able to complete the instructions prior to the lunch hour. If not, then we'll resume at 1:30 and I'll complete them and then have you begin your deliberations. Ladies and gentlemen of the jury, you have heard all of the evidence and the arguments of the attorneys, and it is now my duty to instruct you on the law that applies to this case. The law requires that I read these instructions to you, and you'll also have the instructions in their written form in the jury room to refer to during your deliberations. You must base your decision on the facts and the law. You have two duties to perform. First, you must determine the facts from the evidence received in the trial and not from any other source. A fact is something proved directly or circumstantially by the evidence or by stipulation. A stipulation is an agreement between the attorneys regarding the facts. Second, you must apply the law that I state to you to the facts as you determine them, and in this way arrive at your verdict and any finding you are instructed to include in your verdict. You must accept and follow the law as I state it to you, whether or not you agree with the law. If anything concerning the law said by the attorneys in their arguments or at any other time during the trial conflicts with my instructions on the law, you must follow my instructions. You must not be influenced by pity for a defendant or by prejudice against him. You must not be biased against the defendant because he has been arrested for this offense, charged with a crime, or brought to trial. None of these circumstances is evidence of guilt, and you must not infer or assume from any or all of them that he is more likely to be guilty than innocent. You must not be influenced by mere sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling. Both the people and the defendant have a right to expect that you will conscientiously consider and weigh the evidence, apply the law, and reach a just verdict, regardless of the consequences. If any rule, direction, or idea is repeated in different ways in these instructions, no emphasis is intended, and you must not draw any inference because of its repetition. Do not single out any particular sentence or any individual point or instruction and ignore the others. Consider the instructions as a whole and each in light of all the others. The order in which the instructions are given has no significance as to their relative importance. Statements made by the attorneys during the trial are not evidence. Although, if the attorneys have stipulated or agreed to a fact, you must regard that fact as conclusively proved as to the party or parties making the stipulation. If an objection was sustained to a question, do not guess what the answer might have been. Do not speculate as to the reason for the objection. Do not assume to be true any insinuation suggested by a question asked a witness. A question is not evidence and may be considered only as it enables you to understand the answer. Do not consider for any purpose any offer of evidence that was rejected or any evidence that was stricken by the court. Treat it as though you had never heard of it. You must decide all questions of fact in this case from the evidence received in this trial and not from any other source. You must not make any independent investigation of the facts or the law or consider or discuss facts as to which there is no evidence. This means, for example, that you must not on your own visit the scene, conduct experiments, or consult reference works or persons for additional information. You must not discuss this case with any other person except a fellow juror, and you must not discuss the case with a fellow juror until the case is submitted to you for your decision, and only when all jurors are present in the jury room. The evidence consists of testimony of witnesses, writings, material objects, or anything presented to the senses and offered to prove the existence or non-existence of a fact. Evidence is either direct or circumstantial. Direct evidence is evidence that directly proves a fact without the necessity of an inference. It is evidence which by itself, if found to be true, establishes that fact. Circumstantial evidence is evidence that, if found to be true, proves a fact from which an inference of the existence of another fact may be drawn. An inference is a deduction of fact that may logically and reasonably be drawn from another fact or group of facts established by the evidence. It is not necessary that facts be proved by direct evidence. They may be proved also by circumstantial evidence or by a combination of direct evidence and circumstantial evidence. Both direct evidence and circumstantial evidence are acceptable as a means of proof. Neither is entitled to any greater weight than the other. However, a finding of guilt as to any crime may not be based on circumstantial evidence unless the proof circumstances are not only 1, consistent with a theory that the defendant is guilty of the crime, but 2, cannot be reconciled with any other rational conclusion. Further, each fact which is essential to complete a set of circumstances necessary to establish the defendant's guilt must be proved beyond a reasonable doubt. In other words, before an inference essential to establish guilt may be found to have been proved beyond a reasonable doubt, each fact or circumstance upon which such inference necessarily rests must be proved beyond a reasonable doubt. Also, if the circumstantial evidence as to any particular count is susceptible of 2 reasonable interpretations, one of which points to the defendant's guilt and the other to his innocence, you must adopt that interpretation which points to the defendant's innocence and reject that interpretation which points to his guilt. If, on the other hand, one interpretation of such evidence appears to you to be reasonable and the other interpretation to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. The specific intent or mental state with which an act is done may be shown by the circumstances surrounding the commission of the act. However, you may not find the defendant guilty of the crime charged in counts 1, 2, and 3, or the crime of voluntary manslaughter, which is a lesser crime, unless the proved circumstances are not only 1, consistent with the theory the defendant had the required specific intent or mental state, but 2, cannot be reconciled with any other rational conclusion. Also, if the evidence as to any such specific intent or mental state is susceptible of 2 reasonable interpretations, one of which points to the existence of the specific intent or mental state, and the other to the absence of the specific intent or mental state, you must adopt that interpretation which points to the absence of the specific intent or mental state. If, on the other hand, one interpretation of the evidence as to such specific intent or mental state appears to you to be reasonable, and the other interpretation to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. If you find that before this trial, the defendant made a willfully false or deliberately misleading statement concerning the crimes for which the defendant is now being tried, you may consider such statement as a circumstance tending to prove a consciousness of guilt. However, such conduct is not sufficient by itself to prove guilt, and its weight and significance, if any, are matters for your determination. If you find that the defendant attempted to persuade a witness to testify falsely or attempted to fabricate evidence to be produced at the trial, such conduct may be considered by you as a circumstance tending to show a consciousness of guilt. However, such conduct is not sufficient by itself to prove guilt, and its weight and significance, if any, are matters for your determination. If you find that an effort to procure false or fabricated evidence was made by another person for the defendant's benefit, you may not consider that effort as tending to show the defendant's consciousness of guilt unless you also find that the defendant authorized such effort. If you find the defendant authorized that effort, such conduct is not sufficient by itself to prove guilt, and its weight and significance, if any, are matters for your consideration. If you find that the defendant attempted to suppress evidence against himself in any manner, such as by destroying evidence or by concealing evidence, such attempt may be considered by you as a circumstance tending to show a consciousness of guilt. However, such conduct is not sufficient by itself to prove guilt, and its weight and significance, if any, are matters for your consideration. Certain evidence was admitted for a limited purpose during the trial. At the time the evidence was admitted, you were admonished that it could not be considered by you for any purpose other than the limited purpose for which it was admitted. Do not consider such evidence for any purpose except the limited purpose for which it was admitted. Neither side is required to call as witnesses all persons who may have been present at any of the events disclosed by the evidence, or who may appear to have some knowledge of these events, or to produce all objects or documents mentioned or suggested by the evidence. Evidence that on some former occasion a witness made a statement or statements that were inconsistent or consistent with his or her testimony in this trial may be considered by you not only for the purpose of testing the credibility of the witness, but also as evidence of the truth of the facts as stated by the witness on such former occasion. If you disbelieve a witness's testimony that he or she no longer remembers a certain event, such testimony is inconsistent with a prior statement or statements by him or her describing that event. Every person who testifies under oath is a witness. You are the sole judges of the believability of a witness and the weight to be given the testimony of each witness. In determining the believability of a witness, you may consider anything that has a tendency and reason to prove or disprove the truthfulness of the testimony of the witness, including but not limited to any of the following: the extent of the opportunity or the ability of the witness to see or hear or otherwise become aware of any matter about which the witness has testified; the ability of the witness to remember or to communicate any matter about which the witness has testified; the character and quality of that testimony; the demeanor and manner of the witness while testifying; the existence or non-existence of a bias, interest, or other motive; evidence of the existence or non-existence of any fact testified to by the witness; the attitude of the witness towards this action or toward the giving of testimony; a statement previously made by the witness that is consistent or inconsistent with the testimony of the witness; the character of the witness for honesty or truthfulness or their opposites; an admission by the witness of untruthfulness; past criminal conduct of the witness. Discrepancies in a witness's testimony or between his or her testimony and that of others, if there were any, do not necessarily mean that the witness should be discredited. Failure of recollection is a common experience, and innocent misrecollection is not uncommon. And it is a fact also that two persons witnessing an incident or a transaction often will see or hear it differently. Whether a discrepancy pertains to a fact of importance or only to a trivial detail should be considered in weighing its significance. A witness who is willfully false in one material part of his or her testimony is to be distrusted in others. You may reject the whole testimony of a witness who willfully has testified falsely as to a material point, unless from all of the evidence you believe the probability of truth favors his or her testimony in other particulars. You are not bound to decide an issue of fact in accordance with the testimony of a number of witnesses, which does not convince you, as against the testimony of a lesser number or other evidence which appeals to your mind with more convincing force. You are not to disregard the testimony of the greater number of witnesses merely from caprice, whim, or prejudice, or from a desire to favor one side against the other. You must not decide an issue by the simple process of counting the number of witnesses who have testified on the opposing sides. The final test is not in the relative number of witnesses, but in the convincing force of the evidence. Evidence has been introduced for the purpose of showing that a witness, L. Jerome Oziel, engaged in past criminal conduct. Such evidence may be considered by you only for the purpose of determining the believability of that witness. The fact that the witness engaged in past conduct, if it is established, does not necessarily destroy or impair a witness's believability. It is one of the circumstances that you may take into consideration in weighing the testimony of such witness. Evidence of the character of a witness for honesty or truthfulness or their opposites may be considered in determining his or her believability. You should give the testimony of a single witness whatever weight you think it deserves. However, testimony by one witness which you believe concerning any fact is sufficient for the proof of that fact. You should carefully review all the evidence upon which the proof of such fact depends. Motive is not an element of the crime charged and need not be shown. However, you may consider motive or lack of motive as a circumstance in this case. Presence of motive may tend to establish guilt. Absence of motive may tend to establish innocence. You will therefore give its presence or absence, as the case may be, the weight to which you find it to be entitled. A confession is a statement made by a defendant other than at his trial, in which he has acknowledged his guilt of the crimes for which such defendant is on trial. In order to constitute a confession, such statement must acknowledge participation in the crimes as well as the required criminal intent or mental state. An admission is a statement made by the defendant other than at his trial, which does not by itself acknowledge his guilt of the crimes for which such defendant is on trial, but which statement tends to prove his guilt when considered with the rest of the evidence. You are the exclusive judges as to whether the defendant made a confession or an admission, and if so, whether such statement is true in whole or in part. If you should find that the defendant did not make the statement, you must reject it. If you find that it is true in whole or in part, you may consider that part which you find to be true. Evidence of an oral confession or oral admission of the defendant should be viewed with caution. If you should find from the evidence that there was an occasion when the defendant, 1, under conditions which reasonably afforded him an opportunity to reply, 2, failed to make a denial or made false, evasive, or contradictory statements in the face of an accusation expressly directed to him or in his presence, charging him with a crime for which such defendant is now on trial or tending to connect him with its commission, and 3, that he heard the accusation and understood its nature, then the circumstance of his silence and conduct on that occasion may be considered against him as indicating an admission that the accusation thus made was true. Evidence of such an accusatory statement is not received for the purpose of proving its truth, but only as it supplies meaning to the silence and conduct of the accused in the face of it. Unless you find that the defendant's silence and conduct at the time indicated an admission that the accusatory statement was true, you must entirely disregard the statement. No person may be convicted of a criminal offense unless there is some proof of each element of the crime independent of any confession or admission made by him outside of this trial. The identity of the person who is alleged to have committed a crime is not an element of the crime, nor is the degree of the crime. Such identity or degree of crime may be established by a confession or an admission. A person is qualified to testify as an expert if he or she has special knowledge, skill, experience, training, or education sufficient to qualify him or her as an expert on the subject to which his or her testimony relates. A duly qualified expert may give an opinion on questions in controversy at a trial. To assist you in deciding such questions, you may consider the opinion with the reasons given for it, if any, by the expert who gives the opinion. You may also consider the qualifications and credibility of the expert. You are not bound to accept an expert opinion as conclusive, but should give to it the weight to which you find it to be entitled. You may disregard any such opinion if you find it to be unreasonable. In determining the weight to be given an opinion expressed by any witness who did not testify as an expert witness, you should consider his or her credibility, the extent of his or her opportunity to perceive the matters upon which his or her testimony is based, and the reasons, if any, given for it. You are not required to accept such an opinion, but should give it the weight, if any, to which you find it to be entitled. In examining an expert witness, counsel may propound to him or her a type of question known in the law as a hypothetical question. By such a question, the witness is asked to assume to be true a set of facts and to give an opinion based on that assumption. In permitting such a question, the court does not rule and does not necessarily find that all the assumed facts have been proved. It only determines that those assumed facts are within the probable or possible range of the evidence. It is for you, the jury, to find from all the evidence whether or not the facts assumed in a hypothetical question have been proved. If you should find that any assumption in such a question has not been proved, you are to determine the effect of that failure of proof on the value and weight of the expert opinion based on the assumed facts. In resolving any conflict that may exist in the testimony of expert witnesses, you should weigh the opinion of one expert against that of another. In doing this, you should consider the relative qualifications and credibility of the expert witnesses, as well as the reasons for each opinion and the facts and other matters upon which it is based. A defendant in a criminal action is presumed to be innocent until the contrary is proved, and in case of a reasonable doubt whether his guilt is satisfactorily shown, he is entitled to a verdict of not guilty. This presumption places upon the people the burden of proving him guilty beyond a reasonable doubt. Reasonable doubt is defined as follows. It is not a mere possible doubt, because everything relating to human affairs and depending on moral evidence is open to some possible or imaginary doubt. It is that state of the case which, after the entire comparison and consideration of all of the evidence, leaves the minds of the jurors in that condition that they cannot say they feel an abiding conviction to a moral certainty of the truth of the charge. The persons concerned in the commission of a crime who are regarded by law as principals in the crime thus committed and equally guilty thereof include: 1, those who directly and actively commit the act constituting the crime, or 2, those who aid and abet the commission of the crime. A person aids and abets the commission of a crime when he or she, 1, with knowledge of the unlawful purpose of the perpetrator, and 2, with the intent or purpose of committing, encouraging, or facilitating the commission of the crime by act or advice, aids, promotes, encourages, or instigates the commission of the crime. A person who aids and abets the commission of a crime need not be personally present at the scene of the crime. Mere presence at the scene of a crime, which does not itself assist the commission of the crime, does not amount to aiding and abetting. Mere knowledge that a crime is being committed and the failure to prevent it does not amount to aiding and abetting. In the crimes and allegations charged in counts 1, 2, and 3, and the lesser crime of voluntary manslaughter, there must exist a union or joint operation of act or conduct in a certain specific intent in the mind of the perpetrator. Unless such specific intent exists, the crime or allegation to which it relates is not committed. The specific intent required is included in the definitions of the crimes or allegations set forth elsewhere in these instructions. In the crimes charged in counts 1 and 2, namely murder, there must exist a union or joint operation of act or conduct in a certain mental state in the mind of the perpetrator. Unless such mental state exists, the crime to which it relates is not committed. The mental state required is included in the definitions of the crimes set forth elsewhere in these instructions. In the crime of involuntary manslaughter, which is a lesser crime to the charge in counts 1 and 2, there must exist a union or joint operation of act or conduct in general criminal intent. To constitute general criminal intent, it is not necessary that there should exist an intent to violate the law. When a person intentionally does that which the law declares to be a crime, he is acting with general criminal intent, even though he may not know that his act or conduct is unlawful. When, as in this case, it is alleged that the crime charged was committed on or about a certain date, if the jury finds that the crime was committed, it is not necessary that the proof show that it was committed on that precise date. It is sufficient if the proof shows that the crime was committed on or about that date. All right, now I'm going to go into discussion of the charges, definition of the various charges that you'll be dealing with here. Homicide is the killing of one human being by another, either lawfully or unlawfully. Homicide includes murder and manslaughter, which are unlawful. The defendant is accused in counts 1 and 2 of the information, or indictment rather, of having committed the crime of murder, a violation of section 187. Every person who unlawfully kills a human being with malice aforethought is guilty of the crime of murder in violation of section 187 of the Penal Code. In order to prove such crime, each of the following elements must be proved. 1, a human being was killed. 2, the killing was unlawful. And 3, the killing was done with malice aforethought. Malice may be either express or implied. Malice is expressed when there is manifested an intention unlawfully to kill a human being. Malice is implied when 1, the killing resulted from an intentional act. 2, the natural consequences of the act are dangerous to human life. And 3, the act was deliberately performed with knowledge of the danger to and with conscious disregard for human life. When it is shown that a killing resulted from the intentional doing of an act with express or implied malice, no other mental state need be shown to establish the mental state of malice aforethought. The mental state constituting malice aforethought does not necessarily require any ill will or hatred of the person killed. The word aforethought does not imply deliberation or the lapse of considerable time. It only means that the required mental state must precede rather than follow the act. All murder which is perpetrated by any kind of willful, deliberate, and premeditated killing with express malice aforethought is murder of the first degree. The word willful, as used in this instruction means intentional. The word deliberate means formed or arrived at or determined upon as a result of careful thought and weighing of considerations for and against the proposed course of action. The word premeditated means considered beforehand. If you find that the killing was preceded and accompanied by a clear, deliberate intent on the part of the defendant to kill, which was the result of deliberation and premeditation, so that it must have been formed upon pre-existing reflection and not under a sudden heat of passion or other condition precluding the idea of deliberation, it is murder of the first degree. The law does not undertake to measure in units of time the length of the period during which the thought must be pondered before it can ripen into an intent to kill, which is truly deliberate and premeditated. The time will vary with different individuals and under varying circumstances. The test is not the duration of time, but rather the extent of the reflection. A cold, calculated judgment and decision may be arrived at in a short period of time, but a mere unconsidered and rash impulse, even though it included an intent to kill, is not such deliberation and premeditation as will fix an unlawful killing as murder of the first degree. To constitute a deliberate and premeditated killing, the slayer must weigh and consider the question of killing and the reasons for and against such a choice, and having in mind the consequences, he decides to and does kill. Murder of the second degree is the unlawful killing of a human being with malice aforethought when there is manifested an intention unlawfully to kill a human being, but the evidence is insufficient to establish deliberation and premeditation. Murder of the second degree is also the unlawful killing of a human being when 1, the killing resulted from an intentional act. 2, the natural consequences of the act are dangerous to human life. And 3, the act was deliberately performed with knowledge of the danger to and with conscious disregard for human life. When the killing is the direct result of such an act, it is not necessary to establish that the defendant intended that his act would result in the death of a human being. The crime of manslaughter is the unlawful killing of a human being without malice aforethought. It is not divided into degrees, but is of 2 kinds, namely voluntary manslaughter and involuntary manslaughter. Every person who unlawfully kills another human being without malice aforethought, but with an intent to kill, is guilty of voluntary manslaughter in violation of section 192A of the Penal Code. There is no malice aforethought if the killing occurred upon a sudden quarrel or heat of passion or in the honest but unreasonable belief in the necessity to defend oneself against imminent peril to life or great bodily injury. In order to prove such crime, each of the following elements must be proved. 1, a human being was killed. 2, the killing was unlawful. And 3, the killing was done with the intent to kill. To reduce an intentional felonious homicide from the offense of murder to manslaughter upon the ground of sudden quarrel or heat of passion, the provocation must be of such character and degree as naturally would excite and arouse such passion, and the assailant must act under the influence of that sudden quarrel or heat of passion. The heat of passion which will reduce a homicide to manslaughter must be such a passion as naturally would be aroused in the mind of an ordinarily reasonable person in the same circumstances. A defendant is not permitted to set up his own standard of conduct and to justify or excuse himself because of his passions or because his passions were aroused, unless the circumstances in which the defendant was placed and the facts that confronted him were such as also would have aroused the passion of the ordinarily reasonable person faced with the same situation. Legally adequate provocation may occur in a short or over a considerable period of time. The question to be answered is whether or not, at the time of the killing, the reason of the accused was obscured or disturbed by passion to such an extent as would cause the ordinarily reasonable person of average disposition to act rashly and without deliberation and reflection, and from such passion rather than from judgment. If there was provocation, whether of short or long duration, but of a nature not normally sufficient to arouse passion, or if sufficient time elapsed between the provocation and the fatal blow for passion to subside and reason to return, and if an unlawful killing of a human being followed such provocation and had all the elements of murder as I have defined it, the mere fact of slight or remote provocation will not reduce the offense to manslaughter. To reduce a killing upon a sudden quarrel or heat of passion from murder to manslaughter, the killing must have occurred while the slayer was acting under the direct and immediate influence of such quarrel or heat of passion. Where the influence of the sudden quarrel or heat of passion has ceased to obscure the mind of the accused, and sufficient time has elapsed for angry passion to end and for reason to control his conduct, it will no longer reduce an intentional killing to manslaughter. The question as to whether the cooling period has elapsed and reason has returned is not measured by the standard of the accused, but the duration of the cooling period is the time it would take the average or ordinarily reasonable person to have cooled such passion and for that person's reason to have returned. Neither fear, revenge, nor the emotion induced by and accompanying or following an intent to commit a felony, nor any or all of these emotional states in and of themselves constitute the heat of passion referred to in the law of manslaughter. Any or all of such emotions may be involved in a heat of passion that causes judgment to give way to impulse and rashness. Also, any one or more of them may exist in the mind of a person who acts deliberately and from choice, whether such choice is reasonable or unreasonable. The passion necessary to constitute heat of passion need not mean rage or anger, but may be any emotion, including fear, which causes a person to act rashly and without deliberation and reflection. No specific type of provocation is required to generate the passion necessary to constitute heat of passion, and verbal provocation may be sufficient. A person who kills another person in the honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury kills unlawfully, but does not harbor malice aforethought and is not guilty of murder. This would be so even though a reasonable person in the same situation, seeing and knowing the same facts, would not have had the same belief. Such an honest but unreasonable belief is not a defense to the crime of voluntary or involuntary manslaughter. One who has received threats against his life or person made by another is justified in acting more quickly and taking harsher measures for his own protection in the event of an assault, either actual or threatened, than would be a person who had not received such threats. If, in this case, you believe that one or both of the deceased made prior threats against the defendant, and that the defendant, because of such threats, feared greater peril in the event of an altercation with one or both of them, you are to consider such facts in determining whether the defendant acted in the honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury. Evidence has been received in this case which may tend to show the character of the alleged victims for violent or otherwise abusive behavior. It may be reasoned that a person of such character for violent or abusive behavior would be more likely to act violently or abusively on any given occasion. However, evidence of such character for violent or abusive behavior may be refuted or rebutted by contrary evidence. Any conflict in the evidence of the alleged victim's character for violent or abusive behavior and the weight to be given such evidence is for the jury to decide. A defendant may act in the heat of passion at the time of the killings as a result of a series of events which occur over a considerable period of time. Every person who unlawfully kills a human being without malice aforethought and without an intent to kill is guilty of the crime of involuntary manslaughter in violation of Penal Code Section 192B. In order to prove such crime, each of the following elements must be proved. 1, a human being was killed, and 2, the killing was unlawful. A killing is unlawful within the meaning of this instruction if it occurred in the honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury. The distinction between murder and manslaughter is that murder requires malice while manslaughter does not. When the act causing the death, though unlawful, is done in the heat of passion or is excited by a sudden quarrel, such as amounts to adequate provocation, or in the honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury, the offense is manslaughter. In such a case, even if an intent to kill exists, the law is that malice, which is an essential element of murder, is absent. To establish that a killing is murder and not manslaughter, the burden is on the people to prove beyond a reasonable doubt each of the elements of murder, and that the act which caused the death was not done in the heat of passion or upon a sudden quarrel or in the honest, even though unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury. Murder is classified into 2 degrees, and if you should find the defendant guilty of murder, you must determine this and state in your verdict whether you find it to be murder of the first or second degree. If you are convinced beyond a reasonable doubt that the crime of murder has been committed by the defendant, but you have a reasonable doubt whether such murder was of the first or second degree, you must give the defendant the benefit of that doubt and return a verdict fixing the murder as of the second degree. If you are satisfied beyond a reasonable doubt that the killing was unlawful, but you have a reasonable doubt whether the crime is murder or manslaughter, you must give the defendant the benefit of such doubt and find it to be manslaughter rather than murder. If the evidence establishes that there was provocation which played a part in inducing an unlawful killing of a human being, but the provocation was not sufficient to reduce the homicide to manslaughter, you should consider the provocation for such bearing as it may have on whether the defendant killed with or without deliberation and premeditation. Before you may return a verdict in this case, you must agree unanimously not only as to whether the defendant is guilty or not guilty, but also if you should find him guilty of an unlawful killing, you must agree unanimously as to whether he is guilty of murder in the first degree, murder in the second degree, or voluntary or involuntary manslaughter. If you find that the defendant in this case is guilty of murder of the first degree, you must then determine if one or more of the following special circumstances are true or not true. Murder while lying in wait, and multiple murder convictions. The prosecution has the burden of proving the truth of a special circumstance. If you have a reasonable doubt as to whether the special circumstance is true, you must find it to be not true. If you find beyond a reasonable doubt that the defendant was either the actual killer, a co-conspirator, or an aider and abettor, but you are unable to decide which, then you must also find beyond a reasonable doubt that the defendant with the intent to kill participated as a co-conspirator with or aided and abetted an actor in commission of the murder in the first degree in order to find the special circumstance to be true. You must decide separately each special circumstance alleged in this case. If you cannot agree as to all of the special circumstances, but you can agree as to one, you must take or make your finding as to the one upon which you do agree. In order to find a special circumstance alleged in this case to be true or untrue, you must agree unanimously. You will state your finding as to whether a special circumstance is true or not true on the form that will be supplied. To find the special circumstance referred to in these instructions as murder while lying in wait is true, each of the following facts must be proved. 1, the defendant intentionally killed the victim, and 2, the murder was committed while the defendant was lying in wait. The term while lying in wait within the meaning of the law of special circumstances is defined as a waiting and watching for an opportune time to act, together with a concealment by ambush or by some other secret design to take the other person by surprise, even though the victim is aware of the murderer's presence. The lying in wait need not continue for any particular period of time, provided that its duration is such as to show a state of mind equivalent to premeditation or deliberation. Thus, for a killing to be perpetrated while lying in wait, both the concealment and watchful waiting as well as the killing must occur during the same time period or in an uninterrupted attack commencing no later than the moment concealment ends. If there is a clear interruption separating the period of lying in wait and the period during which the killing takes place, so that there is neither an immediate killing nor a continuous flow of the uninterrupted lethal events, the special circumstance is not proved. A mere concealment of purpose is not sufficient to meet the requirements of concealment set forth in this special circumstance. However, when the defendant intentionally murders another person under circumstances which includes 1, a concealment of purpose, 2, a substantial period of watching and waiting for an opportune time to act, and 3, immediately thereafter a surprise attack on an unsuspecting victim from a position of advantage, the special circumstance of murder while lying in wait has been established. If the murder is done suddenly without a period of waiting, watching, and concealment, the special circumstance of lying in wait is not present. To find the special circumstance referred to in these instructions as multiple murder convictions is true, it must be proved that the defendant has, in this case, been convicted of at least one crime of murder of the first degree and one or more crimes of murder of the first or second degree. You are not permitted to find a special circumstance alleged in this case to be true based on circumstantial evidence unless the proved circumstances is not only, or our circumstance rather, is not only one consistent with a theory that a special circumstance is true, but cannot be reconciled with any other rational conclusion. Further, each fact, which is essential to complete a set of circumstances necessary to establish the truth of a special circumstance, must be proved beyond a reasonable doubt. In other words, before an inference essential to establish a special circumstance may be found to have been proved beyond a reasonable doubt, each fact or circumstance upon which such inference necessarily rests must be proved beyond a reasonable doubt. Also, if the circumstantial evidence is susceptible of two reasonable interpretations, one of which points to the truth of a special circumstance and the other to its untruth, you must adopt the interpretation which points to its untruth and reject the interpretation which points to its truth. If, on the other hand, one interpretation of such evidence appears to you to be reasonable and the other interpretation to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. The specific intent and or mental state with which an act is done may be shown by the circumstances surrounding its commission, but you may not find a special circumstance alleged in this case to be true unless the proved surrounding circumstances are not only 1, consistent with the theory that the defendant had the required specific intent or mental state, but 2, cannot be reconciled with any other rational conclusion. Also, if the evidence as to any specific intent or mental state is susceptible of 2 reasonable interpretations, one of which points to the existence of the specific intent or mental state, and the other to the absence of the specific intent or mental state, you must adopt that interpretation which points to the absence of the specific intent or mental state. If, on the other hand, one interpretation of the evidence as to such specific intent or mental state appears to you to be reasonable, and the other interpretation to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. In your deliberations, the subject of penalty or punishment is not to be discussed or considered by you. This is a matter which must not in any way affect your verdict or affect your finding as to the special circumstances alleged in this case. A conspiracy is an agreement entered into between 2 or more persons with the specific intent to agree to commit the public offense of murder or voluntary manslaughter, and with the further specific intent to commit such offense, followed by an overt act committed in the state by 1 or more of the parties for the purpose of accomplishing the object of the agreement. Conspiracy is a crime, and it's the crime charged in count 3. In order to find a defendant guilty of conspiracy, in addition to proof of the unlawful agreement and specific intent, there must be proof of the commission of at least one of the overt acts alleged in the indictment. It is not necessary to the guilt of any particular defendant that the defendant personally committed the overt act if he was one of the conspirators when such an act was committed. The term overt act means any step taken or act committed by 1 or more of the conspirators which goes beyond mere planning or agreement to commit a public offense, and which step or act is done in furtherance of the accomplishment of the object of the conspiracy. To be an overt act, the step taken or act committed need not in and of itself constitute the crime or even an attempt to commit the crime, which is the ultimate object of the conspiracy. Nor is it required that such step or act in and of itself be a criminal or an unlawful act. The formation and existence of a conspiracy may be inferred from all the circumstances tending to show the common intent, and may be proved in the same way as any other fact may be proved, either by direct testimony of the fact or by circumstantial evidence, or by both direct and circumstantial evidence. It is not necessary to show a meeting of the alleged conspirators or the making of an express or formal agreement. Evidence that a person was in the company of or associated with 1 or more other persons alleged or proved to have been members of a conspiracy is not in itself sufficient to prove that such person was a member of the alleged conspiracy. The act or declaration of a person who is not a member of the conspiracy is not binding upon the members of the conspiracy, even if the act or declaration tended to promote the object of the conspiracy. Evidence of the commission of an act which furthered the purpose of an alleged conspiracy is not in itself sufficient to prove that the person committing the act was a member of such a conspiracy. No act or declaration of a conspirator committed or made after the conspiracy has been terminated is binding upon the co-conspirators, and they are not criminally liable for any such act. The fact that a killing was planned in advance, whether individually or in concert, does not prove that the planner acted with malice or with premeditation and deliberation. If, as a result of heat of passion, sudden quarrel, or an honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury, a man kills without malice, he commits manslaughter. It necessarily follows that if this same man, under those same circumstances, conspires to kill, he conspires to commit manslaughter. In this case, the defendant is charged in count 3 with conspiracy to commit the following public crimes: murder of Jose and Mary Louise Menendez. It is alleged that the following overt acts were committed in this state by one or more of the defendants for the purpose of furthering the object of the conspiracy. Overt act number 1. On August 18, 1989, the defendants purchased 2 Mossberg shotguns in San Diego. Overt act number 2. On or about August 20, 1989, the defendants acquired shotgun ammunition. Overt act number 3. On August 20, 1989, Lyle Menendez contacted his friend Perry Berman by telephone to arrange a meeting later that night to serve as an alibi. Evidence of a statement made by one alleged conspirator other than at his trial shall not be considered by you as against another alleged conspirator unless you determine that from other evidence, other independent evidence, that at the time the statement was made, a conspiracy to commit a crime existed, that the statement was made while the person making the statement was participating in the conspiracy, and that the person against whom it was offered was participating in the conspiracy before and during that time. And 3, that such statement was made in furtherance of the object of the conspiracy or the objective of the conspiracy. The word statement as used in this instruction includes any oral or written verbal expression or nonverbal conduct of a person intended by that person as a substitute for oral or written verbal expression. The defendant is charged in count 3 with conspiracy to commit the crime of murder in violation of Penal Code Section 187, and as a lesser included offense, the crime of conspiracy to commit manslaughter in violation of Penal Code Section 192. In order to find the defendant guilty of the crime of conspiracy, you must find beyond a reasonable doubt that the defendant conspired to commit one or other of the said crimes, and you must also unanimously agree as to which particular crime he conspired to commit. If you find the defendant guilty of conspiracy, you must then include a finding on the question as to which alleged crime you unanimously agree the defendant conspired to commit. A form will be supplied for that purpose. Each crime charges a distinct, strike that, let me start this one over. I'm almost through here. We've got about less than 10 minutes or so to go. Each count charges a distinct crime. You must decide each count separately. The defendant may be found guilty or not guilty of any or all of the crimes charged. Your finding as to each count must be stated in a separate verdict. If you are not satisfied beyond a reasonable doubt that the defendant is guilty of the crime charged, you may nevertheless convict him of any lesser crime if you are convinced beyond a reasonable doubt that the defendant is guilty of such lesser crime. The crime of second-degree murder is lesser to that charged in counts 1 and 2. The crime of voluntary manslaughter is lesser to that charged in counts 1 and 2. The crime of involuntary manslaughter is lesser to that charged in counts 1 and 2. The crime of conspiracy to commit murder in the second degree is lesser to that charged in count 3. The crime of conspiracy to commit voluntary manslaughter is lesser to that charged in count 3. Thus, you are to determine whether the defendant is guilty or not guilty of the crime charged or of any lesser crimes. In doing so, you have discretion to choose the order in which you evaluate each crime and consider the evidence pertaining to it. You may find it productive to consider and reach tentative conclusions on all charges and lesser crimes before reaching any final verdicts. However, the court cannot accept a guilty verdict on a lesser crime unless you have unanimously found the defendant not guilty of the charged or greater crime. And I'll explain that process a little bit further with you when I talk about the verdict forms. I have not intended by anything I have said or done, or by any question that I may have asked, or by any ruling I may have made, to intimate or suggest what you should find to be the facts, or that I believe or disbelieve any witness. If anything I have done or said has seemed to so indicate, you will disregard it and form your own conclusion. The purpose of the court's instructions is to provide you with the applicable law so that you may arrive at a just and lawful verdict. Whether some instructions apply will depend upon what you find to be the facts. Disregard any instruction which applies to facts determined by you not to exist. Do not conclude that because an instruction has been given that I am expressing an opinion as to the facts. The people and the defendant are entitled to the individual opinion of each juror. Each of you must consider the evidence for the purpose of reaching a verdict if you can do so. Each of you must decide the case for yourself, but should do so only after discussing the evidence and instructions with the other jurors. Do not hesitate to change an opinion if you are convinced it is wrong. However, do not decide any question in a particular way because a majority of the jurors or any of them favor such a decision. Do not decide any issue in this case by chance, such as by the drawing of lots or any other chance determination. The attitude and conduct of jurors at all times are very important. It is rarely helpful for a juror at the beginning of deliberations to express an emphatic opinion on the case or to announce a determination to stand for a certain verdict. When one does that at the outset, a sense of pride may be aroused, and one may hesitate to change a position even if it is shown to be wrong. Remember that you are not partisans or advocates in this matter. You are impartial judges of the facts. The instructions which I am now reading to you will be made available in written form for your deliberations. They must not be defaced in any way. You'll find that the instructions may be typed, printed, or handwritten. Portions may have been added or deleted. You must disregard any deleted part of an instruction and not speculate as to what it was or as to the reason for its deletion. You are not to be concerned with reasons for any of the modifications. Every part of the text of an instruction, whether typed, printed, or handwritten, is of equal importance, and you are to be governed only by the instruction in its final wording. Do not disclose. Do not tell in any form, written or verbal or any other way, to anyone outside of the jury, not even to me or any member of my staff, either orally or in writing, how you are divided numerically in your balloting as to any issue until and unless I specifically direct you to do otherwise. You've been given notebooks and pencils, and many of you have been using them during the course of the trial. Leave the notebooks in the jury room at the end of each day. A reminder regarding notes, that your notes are only an aid to your memory and should not take precedence over your independent recollection. A juror who has taken notes should rely, strike that, a juror who has not taken notes, somebody who, and some of you have not taken notes, if you're in that situation, you should rely on your own independent recollection of the evidence and not be influenced by the fact that some other jurors have taken notes. Notes are for the note taker's own personal use in refreshing his or her recollection of the evidence. Finally, should any discrepancy exist between a juror's recollection of the evidence and his or her notes, he or she may request that the reporter read back the relevant proceedings, and the trial transcript must prevail over the notes. Regarding requests for testimony to be read back, let me talk about that for a moment with you. You've seen the lawyers during the trial use transcripts each day after the day's proceedings. The court reporters have worked late into the night preparing the transcript of that day's proceedings and made it available to the lawyers. There's something like, I don't know how many volumes, but there are a lot of them. And each day it perhaps created 200 to 300 pages of typewritten work reflecting each word that was said during the course of the trial. You don't get those. You don't get those transcripts. The only transcripts you will get are transcripts of some of the tape recordings that have been shown to you. During times when tape recordings have been played, on occasion, transcripts have been given to you, and I instructed you at that time that the transcript was given to you solely for the purpose of assisting you in listening to the tape recording. That's one type of transcript, and you'll have some of those in the jury room as exhibits. But the transcripts prepared by the court reporters of the testimony that occurred each day, you don't get that. If you request that some testimony be read back, what happens is that the court reporter will then find that portion of the testimony, if you specify what it is, and that testimony will then be read back by the court reporter. She'll either do it here in open court or in the jury room, depending on how we decide to do it. And then the court reporter would read back, question and answer as that process goes forward. And if it develops that you request that some testimony be reread, I'll describe further the procedure for you. If there is a request made by you to have some testimony read back, it sometimes helps us if you could be specific as to what it is that you're looking for. Sometimes you want only a portion of a witness's testimony, not the entirety of a witness's testimony. If that's the situation, then you can let us know and we'll try to find that for you. Sometimes the request is such where we end up giving you the entire testimony of a witness, depending on how the request is made or what the request is. But we'll give you written forms for you to fill out, making any such requests of us. And when you make requests, whether it's a request for testimony to be read back or perhaps a clarification of the instructions or anything else, if that ever happens, I'm not suggesting that you will make those requests, but if you do, bear in mind, it takes us a little while to get everybody together. I have to talk to the lawyers about the matter, and it takes a little while for everybody to be here. Sometimes they're not in the courthouse, so it takes a little bit of time to get everyone organized, and sometimes it takes us a little while to get the response ready to give to you. So even though you might make a request in the morning, it might, depending on circumstances, be delayed until the afternoon before we can get to it, but we will do it as quickly as possible. At this point, then, what I'll do is discuss with you the verdict forms just briefly. They were discussed to some extent during the argument of counsel. The verdict forms are given to you when you go into your deliberations. As I said, you'll also get the written instructions. It takes a while for these instructions to get to you. The clerk has to process them. And you'll also have the exhibits. It might take a little while to even get those to you, but we'll get them to you sometime this afternoon. As far as the verdict forms are concerned, let me discuss them briefly with you. And as you're aware from the reading of the indictment and the instructions I read to you, the count 1 and count 2 are the two charges of murder. And count 1 is the charge of murder involving the victim, Jose Menendez. Count 2 is a charge of murder involving Mary Louise Menendez. And count 3 is a charge of conspiracy. And there are verdict forms for each of those 3 counts. As I've read to you in my instructions already, as to any of these counts, only one verdict form can be reached, can be signed. Only one verdict can be signed by you. And the verdict forms are, as to the 2 counts, counts 1 and 2, the charges of murder, there are 4 verdict forms. Let me just go through count 1 by way of example here. Count 1 and 2 are identical, so the forms are identical. And you would go through the same process with each as far as dealing with them. If you find that the defendant is guilty of murder in the first degree, then there is a form for you to fill out, and it's the form that says guilty of murder, and there's a place for you to enter in first degree or second degree. And there's a place for you to actually write in first or second degree. It's a blank. If you find the defendant guilty of first degree murder, then as I explained, you have additional responsibility to make findings regarding the special circumstance allegations. On that same verdict form are spaces for you to make findings as to whether those allegations are true or not true. If you find the defendant guilty of voluntary manslaughter, there's a verdict form for that. It's a separate verdict form that is guilty of voluntary manslaughter. If you find the defendant guilty of involuntary manslaughter, there's a form for that. And if you find the defendant not guilty of first-degree murder, not guilty of second-degree murder, not guilty of voluntary manslaughter, not guilty of involuntary manslaughter, then there's a not guilty verdict form to fill out. But as to count 1 and count 2 and count 3, only one of those verdict forms can be filled out. If you find the defendant not guilty of any of those charges, you fill out the not guilty form. Strike that. If you find the defendant not guilty of all of those charges, you fill out the not guilty form. If you find him guilty of one of the 4 options there, first degree, second degree, voluntary or involuntary manslaughter, then you fill out that form and only that form. And as far as the conspiracy charge in count 3, you have 2 verdict forms to deal with, a guilty and a not guilty. If you find the defendant guilty of conspiracy, then there's an additional finding the jury is required to make, as I explained to you in the instructions. That has to do with determining the crime for which the conspiracy was the object of the conspiracy, and the findings are first-degree murder, second-degree murder, or voluntary manslaughter. There's a spot for you to check off for that. And there's also a not guilty verdict form if you find the defendant not guilty of conspiracy. And again, only one verdict form is to be filled out as to count 3. So if you reach verdicts as to count 1, count 2, or count 3, as to any of those 3 counts, only one verdict form per count. So if you have verdicts on all 3 counts, you have 3 verdict forms, and that's it. If you have verdicts on 1 count, then you only have 1 verdict form. So whatever it is, 1 verdict form per count. If you have all agreed upon 1 verdict as to a particular count, as I've indicated, the corresponding form is the only verdict form to be signed as to that count, and the other verdict forms are to be left unsigned. What I'm going to do is now have you retire to the jury room, and we'll just keep you there for a few minutes and then let you take your break. I'll give you a little information about how to proceed with your conduct during deliberations. You shall now retire and select one of your number to act as a foreperson. He or she will preside over your deliberations. In order to reach verdicts, all 12 jurors must agree to the decision and to any finding you have been instructed to include in your verdict. As soon as all of you have agreed upon a verdict, so that when polled, each may state truthfully that the verdicts express his or her vote, have them dated and signed by your foreperson, and then return with them to this courtroom. Return any unsigned verdict forms as well. During deliberations, you'll be taking breaks at various times during lunch, after the day is completed, weekends and things of that sort. It's important to remember that you must not discuss this case outside of the jury room. That means that if you're in the hallway or at lunch and some of the jurors happen to be together, you can't discuss it among yourselves. You must wait until all 12 jurors are in the jury room. By the same token, if 9 or 10 of the jurors are in the jury room and a couple are a little late or whatever coming back in, again, don't talk until all 12 are present in the jury room. And when you're away from the jury room, whether it's among yourselves or with other people, do not talk about the case at all. The only time you can talk about it is when all 12 jurors are in the jury room. By the same token, as to the alternate jurors, there's still the chance that one of the 12 jurors will be replaced and you would take their place. And it's important that you maintain your present situation and be available to replace a juror if that occurs. And it's important in that regard that you not discuss the case among yourselves, not discuss it with anyone else, just proceed as you have during the course of the trial, not talking about it at all, and remain available to step in if we have to substitute you for one of the other jurors. And if that does happen, then the deliberations start all over again, and you would be there, in essence, at the beginning all over again when deliberations start. So it's a situation, as I indicated, where the bailiff will tell you as far as where to return Monday as far as deliberations, location of your deliberations. And we'll certainly keep tabs with you and keep touch with you and know what's going on, so that you'll be able to communicate with me through these written notes, as I've indicated, if there is need to do so. At this point, then, we'll ask that the clerk swear in the bailiff, and he will take charge of the jury and the alternates.
else to speak to them on any matter connected to the case, except on orders of court, when they have agreed upon a verdict to return to the court of social competence. You solemnly swear to take charge of the alternate jurors and keep them apart from the jury while they are deliberating on the causes otherwise ordered by the court.
All right. At this point, then, what I'll do is ask that the 12 jurors go into the jury room and be there for a little while. And if you have time to select your foreperson, you can do that and then take a break for lunch. And the 2 alternate jurors, if you would just, at this point, perhaps just stay there for a second, and then the bailiff will escort you next door until we can get everything organized, and then we'll let you go to lunch as well. And then you'll proceed with your deliberations after lunch. Okay, go ahead.
Skating for over 45 years has taken a toll on my body. I take Cunol turmeric because it helps with healthy joints and inflammation support. Why Cunol? It has superior absorption compared to regular turmeric. Cunol, the brand I trust.
All right, as far as counsel and your presence here, did you have any requests?
But other than that, if we can handle things telephonically, I'd like to do so.
Mr. Bird?
Same.
What about requests by the jury for instructions and things of that sort?
If we can do that. Oh, if the court's going to read them?
Yeah.
Instructions?
Respond to a request by having them come into court? Or would you prefer to do that by writing?
Probably by writing, unless, it really sort of depends on the magnitude of the issue.
Okay, what I'm going to do is ask that you stay here for the balance of the day just to see if there's any immediate requests by the jury. And then I'll permit you to be on call so that you can respond to the courthouse within 1 hour. But I want you to be able to respond to a phone inquiry within 15 minutes, so we can reach you within 15 minutes and get a hold of you. And as far as testimony read back, you want it done in open court, is that what you're saying?
Yes.
Okay. And as far as times when the jury is excused for the day or at recesses, do counsel stipulate that there need not be any further admonitions by the court as far as how they conduct themselves during those times?
So stipulated.
Okay. The defendant will be brought out every day, so we don't have any transportation problems with him. And therefore, we'll be in recess until 1:30, at which time we'll resume with the jury instructions for the co-defendant.
Your Honor, I have not yet prepared the final exhibit list for the Lyle Menendez jury. I'll do that during lunch.
That's fine. I'll wait until I'm done.
Well, I'll try to get this fixed.
Fine. I want to resolve all jury instructions. All the defendants in court with counsel. Defendant Eric Menendez. People are represented. Counsel have given the court 2 packets of instructions, one of which is labeled settled jury instructions and the other is contested jury instructions. I have not reviewed the settled jury instructions. I assume that both sides have agreed to those. Is that correct?
I just got this myself, this packet, just right now. I'm reviewing it right now.
I believe it reflects, Your Honor, and I attempted to give this to Mr. Kuriyama when we arrived here about 11:30, but he wasn't in his office. I think they indicate the jury instructions that we agreed on and submitted to the court the last time we were here, as well as the ones the court ruled on the last time we were here.
Okay, I'll review that. I haven't really looked at it myself, but let's go through the contested ones and see if we can resolve them now. Complete this without too much delay. When you label these contested, these are submitted just by the defense or by the prosecution? Or?
No, Your Honor, the prosecution's
Okay.
as well. They may be marked up, but they're there.
All right. Just chronologically then, what is the people's objection to 2.02? I assume.
I see that my objection was with involuntary manslaughter. I
Okay.
suspect that the court is going to.
Yes, the court's ruling in regards to the lesser included offense will be that the court will instruct on involuntary manslaughter if that is the request of the defense.
It is, Your Honor.
All right, 2.02 will be given, and what I propose to do is use the exact same instruction forms as I gave to the other jury. In the same form that they were given with the same modifications, unless there's someone who wants to speak up about it.
Just individually, right?
All right, 2.03, this is a modification of the standard instruction.
Yes, Your Honor. We have added a second paragraph with, I think, more fully explains the use to which or the weight which a jury might give to such evidence. And I don't think it appreciably changes the instruction. I think it is an appropriate addition to the instruction given the specific facts of this case.
Take a look at his too. Give me his back so I can.
It's not a correct statement of the law, and it's argumentative.
All right, I propose to give the standard instruction. The submission by the defense is refused. .06.
Yes, that's been requested by the prosecution, and there's going to be an objection on behalf of Eric Menendez.
And the objection.
There's no factual basis.
There's no factual basis for it. I don't know what facts.
What about throwing away the guns and the clothing and things like that?
I don't even think that's what's on their mind. That's,
No.
Well, isn't that concealing evidence and destroying
No.
evidence? No, it isn't?
I
thought it
think
was.
that
How could you say it's not?
perhaps Mr. Kuriyama will articulate his theories.
Because I specifically asked him that, Your Honor, the other day, if he meant the guns, and he said, no, it had to do with removing pornographic magazines from various places. That was his reason for
Upon
asking.
discussion, Your Honor, I do have 6 grounds for that particular instruction. One, that the defendant testified that he destroyed evidence from the closet, or had his cousin destroy evidence from his closet after the killings. He himself destroyed tapes of his own phone conversations, which his mother had taped. He had a cousin take and destroy evidence from his Marina City Club apartment at the time of his arrest. And I agree that the burying of shotguns, the throwing away of bloody clothes, and the throwing away of shotgun shell casings also fit within 206.
But, Your Honor, I don't think that's a suppression of evidence. I mean, that's an attempt to conceal after a crime, which is a
How
different concept.
can you do it before the crime? I mean, you're going to conceal the guns before the crime was committed?
You know, you can do many things to conceal, but my point is, it's not a suppression of evidence. It's an effort to conceal instrumentalities of the crime afterwards.
Okay, it's going to be given.
Okay, we would like it
for the instruction.
Okay, we would like an in limine ruling, however, Your Honor, that Mr. Kuriyama cannot get up and say that this particular instruction bears on destroying pornographic magazines or telephone tapes from his mother's intrusion into his private life when no evidentiary value has been shown for those things.
Well, I can't foreclose his argument. If it's supported by the evidence, he can argue it. If it's not, then it's
But there is no
not
evidence
going
as
to
to
be
what the
supported by the evidence.
content of, for example, these telephone tapes were.
How
Just
not
inviting the
gonna-
kind of speculation
At this
that would.
point, all I'm doing is ruling on the instructions. His argument is his argument. I'm not getting into that.
Well,
at
we
this
are
point.
going to ask for an eliminate ruling with respect to his argument, given the argument of his co-counsel today.
All right, let's just focus on what we're here for. We're here to deal with the instructions so that when we start the argument on Monday morning, it will be started at 9:00.
Then can we be here at 8:30 for an eliminate ruling on final
Let's
argument?
finish this. Can't you focus on one thing at a time? This is
can.
it. These are instructions. They're going to be finalized this afternoon expeditiously. 2.10.
Yes, we're requesting that the court give our modified version of 2.10.
I've reviewed the instruction and the nature of the evidence, and the court's view is I'm not going to give the instruction at all. Modified or unmodified.
21.2.
2.21.2, what is this is a submission by the defense. You've modified something.
Yes, Your Honor, we have added a paragraph to attempt to define material part of his or her testimony. Basically, this instruction tells the jury that they may disregard and distrust a witness who is willfully false in one material part of his or her testimony. And I think that it is appropriate to try and define the material part. We have done so by stating that it refers to testimony which is of such significance that it could be determinative of the case if believed or disbelieved. And I think it more appropriately focuses the jury.
The case cited.
I'm giving the standard instruction. I don't see any reason to modify. These are efforts by one side or the other to modify the standard instructions that are given in every case. No reason to do so.
We're skipping
What's
over
been
the
presented
standard
here?
ones, please now. These are the ones in contest. Is that what you're doing? Commissioners, yes, one is being done.
2.52, absence of flight. The case law supports the proposition that instruction not be given. Do you want to argue that?
No, not any further than it's been argued previously in the case.
All right, it's not going to be given.
He's not going to get to his 0.62.
2.62, the court declined giving that instruction in regards to the co-defendant. The people had requested it. The court denied it. The court is inclined to do exactly the same with this instruction with this defendant. The people wish to be heard.
Submitted, Your Honor.
All right, it's not going to be given.
Confession.
2.70. What was the modification here?
The modification was to add a paragraph, the last paragraph indicating that any out-of-court statement made by the defendant that is not an admission or confession should not be viewed with caution.
My view is it's just confusing. I gave the instruction in a standard form with the admonition regarding viewing it with caution and leave it up to the jury to decide what to do, and counsel can argue it as you want as to the reason for that.
So court leave the brackets around the portion on the one you're giving, even though you're giving it?
If the brackets are there and it hasn't come out, I have gone through and processed that on the computer, and just before I was ready to print them out, the computer said error, and I lost it
Bye.
all, and I wasn't going to do it again. So
Know the feeling.
just the brackets are there if they're there.
Okay. I've had the same thing happen. Computers. That's why I always back everything up on a disk
Well,
at the
it's something
same
which I'm
time.
backing it up. It was just right there being processed, and
Bingo.
said Windows something or another, and decided didn't want it.
It said tilt. Okay.
All right, so 2.70 is being given in its standard form, just as it was to the other jury,
2.71.
or 2.70. And then 2.71 is not going to be given since 2.70 is given.
Right. 2.71.5 is good.
2.71.5 is going to be given in the same format as it was to the co-defendant's jury. Counsel wish to be heard.
Yes, Your Honor, we would be objecting to the giving of that. Just to state it briefly, we don't believe that the circumstances under which the statements were made to Dr. Oziel by Lyle Menendez in the presence of Eric Menendez are such as to qualify for an adoptive admission. Specifically, the elements of confrontation, accusation are lacking in this case, and I don't think that given the circumstances of October 31st and November 2nd, that Eric Menendez was in a position or could reasonably have been expected to say anything given the dynamics of what was going on.
Well, this was discussed at the time the litigation occurred relating to the admissibility of the evidence, and the court made determinations at that time that these were adoptive admissions. So at this point, it would be necessary to instruct the jury along those lines.
I would just add, Your Honor, with respect to the 1211 tape, the fact of Eric's demeanor on for a good portion of that tape, his silence for a good portion, and then his demeanor when he does start speaking, I think vitiates strongly against any of that material that Lyle is saying is being an adoptive admission, and we would ask for an instruction that, I don't know if we did, that directs the jury's attention that 1211 does not contain adoptive admissions.
That's up to the jury to evaluate and counsel to argue, but the instruction's appropriate without isolating on a specific conversation. So I will give 2.71.5 as I modified it with the co-defendant offenses requested and modified 2.90, the reasonable doubt instruction, modifying it. I assume you're doing that just to preserve the record.
Could we talk about 2.83, Your Honor? That the court
It's not in dispute.
Well,
2.83
8.3 is not submitted in our case.
2.83 wasn't submitted. That's the,
Well, the other side asked for it, then it won't be given. I don't care.
Okay,
okay.
resolution of conflicting, there is no conflicting.
We're just going to go down this list now.
I know, but I'm going through the judge's pile to make sure I know what we're doing.
They know 2.83. Okay, 2.90 is going to be given in its standard form. 3.0. People have submitted. What is the defense objection?
3.0.
And 3.01, aid and abet.
You don't.
No objection. We've gone back and forth, but I think our final position is.
All right, we ultimately gave it as to the co-defendant, and it becomes necessary in light of the long paragraph in the special circumstance instruction regarding intent, if the person was an aider and abetter.
Mm-hmm.
So 3.00 and 3.01 will be given in the form that was given to the co-defendant's jury. What about 3.02? Is there any need for that?
It's 3.02.
That's and one of the aiding and abetting
Yeah.
instructions.
People are offering that.
I'm offering that.
Oh, you've seen it. You
Person's guilty of the act
Other
committed
crimes.
and
There are no other crimes.
natural and probable consequences of the,
I don't think it applies at all in this case.
No, it
And it's
doesn't seem
unduly
to, it just-
confusing.
what is it that you're looking at, Mr. Kuriyama?
Well, if the defendant were to say that he went in there just to assist in firing at his parents, and the natural and probable consequences of that led to the killings, or to their deaths, I think that's what I was thinking when I asked for Calcic 3.02.
Do you want to be heard?
But that's the homicide. That's the aiding and abetting to the principal crime.
All right, the court is going to reject that instruction. It just doesn't meet the facts of this case.
3.31.
3.31,
I think the prosecution's objection was to the inclusion of manslaughter, so perhaps they,
as to voluntary manslaughter. It should be voluntary manslaughter.
yes.
Right.
That,
For specific intent.
All right, and then the court will give that as I gave to the other jury, and 3.30 also,
General.
which is general intent for involuntary.
Right.
yes.
And then 3.31.5 will be given. The mental state doesn't apply to manslaughter, just to murder.
Exactly.
So you've put it in there for
Yes.
manslaughter.
Yes.
Well, mental state is malice. So that's-
Yeah.
It's malice.
So I'll give the same one I gave to the other jury.
Already done.
4.71.
No objection, Your Honor.
I don't know why we need it, but.
Well, there was some dispute about the date of the conspiracy, as I recall.
Oh, okay.
No, this is the next dispute.
5.17.
Yes.
Where's the court's 5.17? Just a second.
It's there after the manslaughter instructions.
Right. Is it before involuntary?
Yeah, it's there.
It's gotta be here before him.
You're still in the 8th.
I know I'm in the 8s, but I think the judge put it in the 8s. Here's the murder. Is it after all the 8s, Judge?
No, I don't have the order that you have, so.
I have whatever was given to Penny. Here it is. Honest but unreasonable belief. Okay. But if it's just going to give the standard.
I'm just going to give the standard instruction. I don't see any reason to modify it.
Our position on 5.17 depends on whether there's you haven't had a chance to look at it, whether there's a special instruction on the definition of imminence.
I didn't give that.
Okay, fine, then we don't object to 5.17 as Calgic version.
Six point 1.10, the defense submission. What is it that's been modified?
There's been a paragraph added to tell the jury that to be an overt act, the act must precede the commission of the crime if the prosecution is alleging to have been the object of the conspiracy.
Where is that?
Last paragraph.
And the people's response.
You have a moment, Your Honor?
All right, I'll give the defendant's version, including that last paragraph. Everything else in that instruction is identical to the standard 6.10. 6.11. Is requested by the defense. What is this a modified or a standard instruction? You haven't indicated it was modified.
No, it's not modified, it's standard.
What is the people's position as to whether 6.11 is to be given?
That's fine, Your Honor.
All right, it was not given as to the co-defendant's jury. Also, it's incorrect in that it has a conspiracy to commit involuntary manslaughter.
That's true.
So the people have a theory as to why they have a conspiracy. Why do you even need it?
Yeah.
We'll withdraw it.
It really
Fewer instructions for better.
doesn't add anything here. It's not like they conspired to do one thing and then went off and did something else. That's the nature of the evidence that people have offered. They only have one theory.
Right.
All right, it'll be withdrawn then. 6.11 is withdrawn. 6.23. What is the objection to this one? The only difference between this and the one given to the other jury is that the defense has included conspiracy to commit the lesser offense. That's not really what's charged in count 3. It's charged conspiracy to commit the murder of.
And the lesser.
And the lesser.
Well, that's not the charge. To be technically correct, it's just a lesser included manslaughter. Why not just give the one I gave to the other jury?
Well, because, Your Honor, I think it's important for the jury to understand that there can be a conspiracy to commit a manslaughter, whether it be voluntary or involuntary.
Well, it can't be for involuntary, number
Right,
one.
yeah.
Number two, they're going to be told about that as a lesser included offense. This is just telling the jury that there's 3 overt acts, basically. That's the only purpose of this. Telling them there's a charge of conspiracy.
Well, why don't we just have it read, in this case, the
Right.
defendant is charged in count 3 with conspiracy. It is, period.
Right,
It is
period.
alleged that the following overt acts were committed in this, that's all.
That would
And we don't
eliminate,
get hung up with, it can only be conspiracy to commit murder, or it's also conspiracy to commit a lesser included. I mean, it's just to explain the overt acts of the conspiracy.
People wish to be heard.
Your Honor, I think that the way that it was stated for the other jury, which is with conspiracy to commit the following public crimes, is a correct statement of the law. It's a correct statement of what he was charged with. And I think the court made it very clear in its discussion of how the form should be filled out, that conspiracy to commit voluntary manslaughter is a lesser included offense.
The indictment charges the defendant with conspiracy to commit the crime of murder of Jose and Mary Louise Menendez. So that's how the jury will be instructed. I'm just going to give the standard 6.23 as I gave to the other jury. .25.
the other jury is the same one that we've proposed.
Yes, it's the one that was requested by Lyle Menendez. Right.
All right, that's what I will give, same one.
Six.
6.26 is just the verdict form, and you can look at the verdict form. It's already been prepared. 8.11. Just the standard.
Ours is the standard.
Right.
too.
Ours is the
Okay, well, people object to that.
No, Your Honor.
All right, it'll be given standard instruction.
And implied malice is going to be given, I take it, Your Honor.
Yeah, just to put on the record, well, let me first ask the position of the parties as to whether you want implied malice as well as express.
Yes, Your Honor. The court is going to give the involuntary manslaughter instruction, and we will request the implied malice.
Defense wish to be heard.
It was submitted.
All right, it'll be given both implied and express malice. 8.74. Is this just a standard instruction?
8.75.
All right, I suppose the objection before was to involuntary.
Yes.
All right, it'll be given in the same form as I gave to the other jury.
Everything else can object.
8.80. What is the people's objection to? Well, first of all, what is the modification? Did you just remove certain things or?
No, that's ours. I'm sorry.
Yes, Your Honor, the modification, Your Honor, was to the third paragraph, and let me just contrast it with the one the court gave. We modified it to take out the actual killer.
Right, since our client isn't.
And why'd you do that?
Because I don't think the evidence supports a finding that he is, as opposed to an aider and abetter.
I mean, it conclusively establishes that he is not, or just the inference can be drawn that he's not?
I think
Well, with respect to the father, I think it can be conclusively established since none of the other wounds were fatal except the one to the head that his brothers admitted, and I think that's conclusively established.
Well, if it's believed. No,
I
that's
guess
still
they can
a
assume Mrs.
question.
Bazanich did it if they want to
No,
believe
they
it.
can
but-
assume that, or infer that your client did it because someone says someone else did it. It's still a question of fact. These things are for the jury to decide. I was going to give the same instruction in the same form that was given to the codified.
Special 14.
Instruction number 5.
Yes.
This is covered by other instructions, is not
Which one? I'm gonna ask you for specifically.
reasonable doubt as to whether
Well,
it's first or second, or murder or manslaughter.
it is covered somewhat, but I don't think it unduly highlights a very difficult area.
Well, it's just repetitious, the same thing. I'm going to reject it.
Now,
They're not,
Right.
He's not giving.
with respect to our special number 6, the prosecution has withdrawn their imminence instruction, so we will withdraw this as
I don't know
well.
if they withdrew, if the judge isn't doing it.
It's refused. Number 9. I think this is covered by other instructions. The definition of unreasonable self-defense. I'm not going to give that. It's refused. Number 10.
Nice try.
There are cases approving this instruction in civil cases.
Which one?
They're
Number
cited-
10,
Yeah, civil cases.
Yeah, those cases cited by counsel, Lysick and Lindsay, had to do with expert evidence in a malpractice suit. It has to do with an extension of the medical malpractice standard of care, that the experts can establish what that standard is. It's inapplicable in this situation.
All right, I'm not going to give that. I don't think that's an accurate statement of the law.
2.8 specifically says they can reject the testimony.
12.
There is an instruction.
That's included in the other instructions I gave for the other jury. I don't recall the numbering of it. If you want to,
It's special instruction number 10.
yes, it is, and I think it's covered by
Well,
Our
except
going.
yours is typed better or
ours is different.
what way?
Number 1,
The
ours.
last paragraph, I suppose. I don't think it's the same.
Yes. And also, we didn't ask for the refutation or rebutted by contrary evidence section. They did, right?
That was submitted by the defense.
The other defense.
Yes, well, it was submitted by us because my understanding was if the court was going to give this instruction, it would give it with paragraph number 2. And if paragraph number 2 was omitted, it wasn't inclined to give the instruction. That was my recollection of the court's ruling.
But you're talking about their special number 10 or our number 12?
Yes. Our number 12 is a separate instruction.
Okay. Let me look at theirs.
It comes after 5.17. It's two instructions after 5.17 in your package.
Okay, that's,
This way.
yeah, the second paragraph is, number one, it really is unnecessary as phrased. Why would we be telling the jury what is and is not admissible? It's evidence they've heard, so we wouldn't be telling them it's admissible.
This is
You're talking about R number 12.
Yeah.
Okay. Well, we can do. Why don't we just take out paragraph 2 on our special 12 and use 1 and 3?
Of course, it's, I don't know if you have other instructions here that deal with that, but it limits the use of this evidence that you apparently want to use for more than just this purpose.
Well,
you
no,
want
they're
to
already-
show the state of mind of the defendant, I suppose.
Oh, you're talking about the good faith instruction? Oh, but goodness, wait a minute. Because there is one that you gave there, special number 10, sets up the character evidence aspect of it.
And that's all it would be admissible for, or not
Right.
just character, but also for the state of mind of the person who knew of this.
Well, that's not related to special 10. I'm not sure where it shows up. We submitted one about prior abuse. I don't think we've gotten there yet. Let me see what it is. That's our special. Well, it's not quite the same.
I would say that you can start out with your first paragraph of number 12, and then the last paragraph would say such evidence may be considered in deciding whether or not.
Whether or not.
Well, the way you,
Whether or not it was the defendant or.
Or whether or not the defendant had a good faith belief. They're two different concepts. Had an honest belief. Honest but unreasonable belief we need to defend.
I mean, just that.
Yes.
I think so. I think if you start getting into who's the aggressor, it gets really complicated.
Well, depending on how you're arguing it, it might create problems. So what do you want? Such evidence may be considered,
In determining whether or not the defendant had an honest but unreasonable belief in the necessity.
Well, let me just, can we hold this for last? Let me think of what
okay,
words
you think
make
about it,
the most
come
sense.
back to that.
Right.
Number 13. right, that conforms with what I've told the jury before. Any objection to that?
No objection, Your Honor.
Okay, any of these that I'm going to give that are being submitted by the defense, if you could give me another copy so I can insert it in the package, I appreciate it.
15.
Number 15.
Is, because I know the court does not like the middle paragraph of this, and that was only submitted when we thought we had an imminence problem. What we can simply do is take 517 and the imminent, and just insert, just make another one, which
Well,
is,
why can't you just have 517 in addition to
it just gets very,
imminent peril of death or great bodily injury, or
commission of of a forcible and atrocious crime. Okay,
is that agreeable?
Yes, Your Honor.
And then you have it.
but then we need a definition that's not, I mean, it's a forcible and atrocious crime.
Yeah, well, you can do that on the same instruction.
So that will all be incorporated
this.
into 517?
Yeah.
Put it in here. I'll put it in here so I know. Injury, or, commission.
You know, if you want to give me that too.
Okay.
We didn't give this.
Number 17.
No, I think the court has previously read Seja.
I have not, I have refused this instruction, and I'll do the same. Number 19. I've given a different instruction that covers this territory. Doesn't have the delusion and things in it. That's from a case involving a defendant with
Wait a minute, I want to see where this one is.
mental illness.
Which instruction do you believe covers this, that you gave?
Well, the defining,
It was special instruction.
No, you gave the
14.
one that defined what constitutes heat of
Yeah.
passion. This has to do with actual belief in the necessity to defend. That negates malice may be the product.
well, that's covered in 5.17. It's an honest but unreasonable belief. Unless you have somebody who's delusional or, there's some evidence of that, I don't see the reason to give this instruction.
Well, because we want to show that the belief can be based upon fear, mistaken perception, or a history of abuse.
That's all honest and unreasonable belief covered by that.
That's exactly what we're trying to tell the jury, that what
It's
honest but
argumentative,
unreasonable.
Yeah, that it's covered in a definition, and you have to argue it. You can't, the court shouldn't be required, or the court should not direct attention to specific evidence. That's what counsel's arguing.
Which one is
All right, that's refused. 19 is refused. 20. Why do we need that?
Because he's a psychologist, and many other psychologists testified, and there are special instructions dealing with experts, and we don't want the jury to confuse him with them, since he was not qualified, was not examined as an expert witness. And I don't want them to evaluate his testimony as they would an expert witness's testimony.
The defense had witnesses critique Dr. Ozio as though he had testified as an expert. What his background in psychology was. And are we to also include Mark Heffernan in this instruction? And are we to then explain to the juries that, or to this jury, that these witnesses testified only as recipient witnesses rather than expert witnesses?
I don't see the basis for the court giving an instruction identifying one person as an expert or non-expert witness. that's based on their testimony, and the jury can evaluate it. I'm not going to give that. 21.
Yes.
Our objection is it's clearly argumentative. It presupposes certain things having been established, and in form, it's quite argumentative and assumes too much.
It does seem to be argumentative.
Well, we think it's very important, Your Honor, because it's not just the notion of prolonged provocation, but a notion of an entire history of provocative conduct, which is a different concept, can constitute under the law sufficient provocation if they so find it.
Well, they're instructed on provocation, and they have many instructions along those lines, and I think it covers territory, and this is going to be refused.
That's not,
2 is not being given.
2 is ours. And then 3
That's
is-
People's 2 and People's 3.
that should be good.
Well, it's defined in the instruction as forcible, so
Exactly.
why do we need this? The instruction that will be in part of 5.17 will define the felony, atrocious felony, as forcible.
in fact, we should probably ask for an instruction that says forcible includes threatened and feared,
Right.
and not just actual physical violence, but then we could go down that path forever.
So I don't see a need for this.
Okay.
It's going to be refused. People's instruction is refused. All right, that concludes all of the instructions in dispute. Is that right?
I believe so, Your Honor.
Yeah, yes, the court is going to give again what was labeled in the previous, in the other trial, special instruction 10, special instruction 15.
We close out this one.
All the special instructions I gave in the first, for the other defendant.
Your Honor, did we do 12, special instruction 12? Was that resolved finally?
No, I
No,
want to look at
she
it for
was
a
still
minute and write it. Okay, let me just look at it for a minute and see what the.
All right, I would ask that both sides review the list of settled instructions to verify that that's correct. And to the extent, and I assume it's correct in stating that that list has on it all the same instructions I gave to the other jury. There's nothing
Yes.
different in there, so I'll give those same instructions. And those special instructions you've labeled there are really the same version of the instructions for the other defendant, different numbering,
Yes.
so I don't have to correlate them.
And I can tell you which is which.
Well, if you want to substitute yours with a label on it with your client's name
Right.
and bring it to me on Monday and with a little sticker on it telling me which it was for the other defendant, I can.
Well,
I can do that
Substitute
right
them.
now because I have
Number
them.
3 is
Okay,
one,
that's fine.
number 10
Then I
is
can just
11.
put them in the packet and remove the other one.
Your Honor, there were a couple of instructions that were included for the co-defendant that I assume are not going to be given to our jury, which is 2.04, 2.05.
Well, they weren't offered.
Right. I just want to make
Yeah,
sure
but definitely,
they're in the
yeah,
pack.
there were some that were pinpoint instructions relating to specific evidence relating to the co-defendant.
Right, and as well, we had submitted 2.50, which was not given in the co-defendant's package, and which I agreed had been, which I understood had been agreed to by the prosecution.
I mean, in your agreed
Yes,
packet.
yes, that's the evidence of other crimes and the
Right.
purpose for which the jury could
Okay,
consider
well,
the,
let him review the entire packet, and then we'll, and if there are specific things that you want to deal with.
Number 3.30.
Right,
3.30. Judge, I have the 5.17 with the additional atrocious crime. Can I give this to the clerk and have her make a copy so you'll have?
Yeah.
And then, I'm sure you'll redo it on your computer, and then I'll
Yeah.
have a copy for my
Yeah.
pack. And I'm still working on
Okay, do you want me to take a break here? Or let's deal with one, you had some objection to argument. So let's do that real quick,
Okay.
very quickly.
very quickly, I don't want to, I don't think that it's appropriate for Mr., since I'm not using the letter that Ms. Lansing used, and I'm not making the reference that she made with respect to Mrs. Menendez and her mother, we would object to Mr. Kuriyama trying to suggest that Eric Menendez is homosexual, or that there was a homosexual secret.
Wait. You had specific objection to use of one instruction, and then we proceeded with discussion of the instructions. I think it was 2.06. Mr. Kuriyama articulated certain
That's a different
evidentiary
issue.
bases for that
Okay,
instruction,
you wanna
and you
go
felt
back
he
to
shouldn't
that?
be able to argue beyond
Beyond
that.
the dumping of the guns and the clothes and the bullets, the things related to the crime, I think he should be prohibited from arguing that it was suppressing evidence to have people take magazines, the contents of which we don't have before us, out of his apartment or out of his house, or that he destroyed or threw away the tapes of that his mother was surreptitiously recording off his telephone. I mean, there's nothing in the record to show those are evidence of anything.
Well, he's entitled to argue inferences from the evidence. If they're not reasonable inferences, then those
But what evidence
inferences
is
will be
there?
rejected. I'm not going to edit his argument. That's just argument. This instruction is a proper instruction, and the facts of this case that your client, by his own testimony, destroyed evidence. So it's a proper instruction.
Moving away from that instruction, I want to come to terms with the homosexuality issue for the 10th time. Since the people were prohibited from putting in any evidence on that issue, and therefore we obviously did not have an opportunity to refute evidence on that issue, I think it would be improper and arguing outside of the scope of the evidence for Mr. Kuriyama to suggest that such a thing is true, or that it was in any way a motive for the shooting, as I understand Mrs. Bozanich indeed did in her arguments today.
Did the people intend to do that?
I intend to argue based on the evidence that's been presented, based on the testimony of Eric Menendez himself. And I think a reasonable inference is that he had homosexual relations, and I intend to argue that.
Well, Your Honor, it's very interesting that the people intend to argue with the court would not allow them to prove, and what we could not defend.
Wait, I didn't stop you from defending anything. You objected to the introduction of it,
Well,
so it was never introduced.
But then if they're going to get up and argue it anyway,
This is the first I've heard of it, that they intended to argue it. So obviously you've given it more thought than I have.
well, I just heard about it, that it was done. So, and knowing Mr. Kuriyama's homophobia, I was sure that it would once again bubble to the surface of the brew in his head.
That's not true, Your Honor. I resent those comments.
Yeah, well, I resent your trying to do this as well, Mr. Kuriyama,
All
so
right,
we're equal in the resentment category.
The bickering back and forth again for these many months doesn't produce much value here. So let's get to the heart of it. Your objection is what?
My objection is that it's outside the scope of the evidence to argue that my client was a homosexual, or that his sexual orientation was in any way a motive for this crime. I understand the argument, the construction that Mrs. Bozanich put on it was that it was to keep that deep and dark secret that the parents were killed. I mean, we are talking speculation on a very high level here, rather on a very low level here.
And the people's response
Again,
to
Your
the
Honor,
basis and evidence for the argument.
I intend to argue that as Eric Menendez testified, that he felt that he had a problem with his sexuality, that his mother, who he had testified himself, had listened to his phone conversations for about a year, going back to the fall of 1988 until the time that he murdered her. He listened to his phone conversations, confronted him, asked him whether or not he was gay, asked him to get a girlfriend. He testified that he had questions about whether or not he was gay. He, in fact, put on evidence that on November 30th, 1989, he bought bumper pads for his bed when, in fact, he had testified before the jury that the only reason why he had problems with his bed is because his father made him kneel on his bed in sexual activity, yet 3 months after he has murdered his father, he is buying bumper pads for that very purpose. Those are just some of the things that I can point to. His father disinherited him, or threatened to disinherit him, and his father had also stated that he was going to disown this defendant. In the 1211 tape, the defendant refers to relationships he had with other people, as he wished he could have told his mother about. There are various pieces of evidence that I intend to point out.
Well, Your Honor.
Yeah, and his father, according to him, called him, said he was gay.
No, he called him faggot, which is different.
Okay, why do you have to get so
Because
emotional about it? Well,
it
just calm
offends
down,
me.
because your arguments really are more persuasive if you can be
No,
rational about it rather than just yelling and screaming.
It offends me that a molested child is being blamed this way for the perversion of his molester, number one. Number two, it prohibits me from proving what Mr. Kuriyama knows, that the person who shared that bed with the bumpers was a beautiful young woman named Noelle Terlesky. And if this indeed was ever even a cognizable issue in this trial, I would have been more than happy to put Eric Menendez's beautiful girlfriends on the witness stand to explain his sexuality. But it was such a red herring with respect to a provable issue that had any relevance to this case from the very beginning. It was simply a matter of Mr. Kuriyama wanting to prejudice the jury against my client. That obviously I did not try to disprove what the court consistently prohibited him from trying to prove. And now for him to be able to get up and take totally neutral information from the record and argue this prejudicial theory, I think, is absolutely wrong, unfair, denies my client the right to confront evidence, denies him the right to put on a defense, to argue these ludicrous speculative theories that his mother confronted him, of which there is no evidence, because she was listening in on his phone calls, no doubt with his homosexual lovers, of which there is not a shred
Bear in
of
mind,
evidence.
there is no jury here. I could hear you and understand you without
I
all the
understand.
emotionality. It really would
Well,
work
I'm
better
sorry,
that
Judge,
way.
you know I am emotional, and I know you don't like it, but that's the way
It's just
I
not
am.
productive. It doesn't help.
Well,
It's counterproductive.
if it
Just
hurts,
calm down.
if it hurts, it shouldn't.
Well, it should be a situation where you can argue rationally and unemotionally.
You know, if I may.
Yeah, I'm not finished, Mr. Kuriyama. The notion that to string together this nonsense and argue that justifies arguing that somehow Eric was homosexual and this was a motive for the homicides, deprives my client of this right to answer any evidence validly before the jury and to put on a defense.
Well, number one, the evidence, whatever is there, is there. The evidence is before the jury.
You know,
However it
intend
came
to-
out, I don't know how it came out, but it's there.
He was on direct examination. That's they tried to make the father look like he was a molester. And counsel knows quite well that I have attempted to bring in witnesses who would testify as to Mr. Menendez, Eric Menendez's homosexuality. So
Okay,
that would be
each side wants to use this hearing as a vehicle to put on whatever evidence you didn't put on during the trial, and that's not the purpose of the hearing. There was offers by the prosecution of evidence. The defense objected to it. The court sustained the objections. Now we're dealing with a proposed argument of the prosecution dealing with that evidence that is currently before the jury and that evidence alone. And the defense is objecting that the prosecution should not be permitted to argue whatever inferences they want to draw from the evidence that is now before the jury. That's all that's being considered by the court, nothing else.
But Your Honor, they're not arguing from inferences. I mean, it's wild speculation of a highly inflammatory nature, the purpose of which is to alienate the jury from my client. And what are they going to argue? Was he a homosexual at 6? Did he make daddy do it? Is it all his fault? If they want to argue that, fine. But I think it's a different kind of argument. I think it's an argument that he is solely designed to inflame the jury against Eric Menendez on the notion that is the creation of Mr. Kuriyama's mind more than anything else, that Eric Menendez was homosexual and that this was the deep, dark secret of this family, that and in order to keep this secret, he killed his parents and then proceeded to go off to Tahoe and meet his girlfriend, who proceeded to live with him for the next 6 months. And if indeed, I mean, that is the notion of arguing within the scope of the evidence, I suppose then I am free to argue all about his girlfriends, on the thinnest of possible evidence in this case.
As I indicated, I intend to only argue on the evidence that has been presented. Council knows that these men that came forward are not figments of my imagination, and I resent.
Well, I object to the
Yeah,
statement that he
excuse me,
came
it's
forward.
my
That's a
turn.
pedophile.
Counsel, let one side finish. You asked to be permitted to finish, and you were given that opportunity, and I'll let the other side.
And I resent council trying to mislead here and claim that the prosecution is homophobic. That is not true. This defendant testified as to his sexuality himself. He injected that into this case. So it's something that we certainly would not have raised, except for the defendant having raised that. So as I indicated, Your Honor, I don't intend to argue anything except that which has been presented in evidence in this case.
All right, and as far as any other issues that council want to deal with relating to argument, either side.
Yes, are we all free now to discuss Mrs. Bazanich's father's abuse?
What are you talking about?
I understand Mrs. Bazanich argued today her life history.
What does that have to do with your case?
Well, I don't even know what it had to do with their case.
Well,
but,
let's focus on your case then and not worry about what happened with the other jury.
well, I would just like to know if we're permitted, therefore, to tell whatever stories we know about other abused people, because I have a stack of mail, 300 letters high, that I'd be more than happy to read to the jury and tell them abuse stories.
No, that is not permissible to go into all sorts of extraneous matters that are not evidence. Counsel are aware of the limits of argument and the latitude that counsel have in argument and the nature of the particular reference before the other jury is something that I dealt with before with counsel in relationship to that jury, and I'm not going to deal with in relationship to this hearing because it doesn't have any relevance to this hearing. We're talking about this case and any other matters that counsel wish to address regarding this defendant and the arguments or any objections you have either side to the arguments for this jury.
Well, I
Anything
suppose I'm just
else?
asking, are we allowed to tell stories that we know about other abused people?
Well, are you proposing to do such?
Well, I certainly could.
No, that's not my question. Are you proposing to do that? Or are you just asking what are you,
I'm just asking what the limits are, since apparently it's been done.
there's something happened with the other case, the other jury, every word that was said before in the argument, the other case, you want to go over it again and see whether it'll be permissible in this one?
No, I'm certainly not interested in talking about Mrs. Bazanich's father per se, but,
Well, but you're interested in talking about the argument before the other jury for some
well, I'm
reason. Why?
interested in knowing if I'm permitted to talk about other examples of abused kids who kill their parents.
No. Certainly not relevant. One very minor reference by the prosecution in an argument or references by counsel throughout the trial to their personal experiences, where they live and where they lived in the past, and things of that nature have occurred during the course of the trial, but that doesn't open the door to relating every thing that counsel's ever read about every person who's ever been involved in the criminal courts or otherwise.
Oh, I wasn't suggesting so broad an opening, nor was I going to refer to Queens again, Your Honor. However, I'm just trying to figure out what the latitude here is in talking about.
Well, the latitude will be the same as it would be in any other case, and you know that.
Well, I don't know that.
Yes, you do.
Your Honor, there's an exhibit left for the Lyle
Yes.
Menendez jury only that was objected to by the defense. I want to withdraw it on the record. It's 256.
All right, you're withdrawing exhibit 256?
Correct. And the clerk requested that I do it on the record, and it is something the defense objected to, so I don't think there's a problem with me withdrawing it
All
without
right.
being here.
Is that for both defendants or
No,
just
it's only
the-
for Lyle Menendez. It's the business plan from MIE, the court recalls.
Do they know that?
I will tell them.
Okay, then if you would do that, if they have no objection, then it will be withdrawn.
Yeah,
Exhibit
I-
256.
Yes, I know they objected all along, so I think they shouldn't mind. Are they in the building?
They should be. They were told to stay for the balance of the afternoon.
All right.
All right, any other matters that council want to discuss?
Yes, Your Honor. With respect to the December 11th, 1989 tape of Eric and Lyle Menendez with Dr. Oziel, on November 12th, I gave defense counsel in this case my corrections to their transcript. this morning, I was able to take a look at the corrected transcript. The corrected transcript incorporates a few of the corrections that I made, but not all of them. We do have disputes as to the transcript still, and I'd ask the court for direction on whether to submit a separate transcript on our behalf, or whether the court would like to listen to the tape itself and make a judicial determination on which transcript should go to the jury.
Your Honor, we would request the court to listen to the disputed portions of the tape since this has gone up and back. Up and back.
This is what?
This has gone up and back. You know, we've listened, we've corrected, and we've borrowed the people's copy, and there's just, people hear things differently, and the court is the ultimate arbiter of what's on their tapes.
Well, do you have a transcript that highlights the disputes?
Yes, I do. I have it right here in the envelope.
Sure.
That's their version. Does that have both versions?
It's your version with my corrections.
Fine.
Yeah.
Okay.
That's fine.
Is this throughout the tape or just a few or?
There aren't that many. In fact,
Throughout the tape.
the ones that I've marked with the papers are really the most important. Some of the differences are rather minor. There are 1, 2, 3, 4, 5, 6 places where I've marked that I'd ask the court to listen to those.
Is it countered?
Those sections.
Did you counter the places on the tape where that shows up?
No, I did not.
Rather than my listening to the whole thing, it would certainly help. Why don't you?
Be then played on the same machine as the counting process.
That's right. I assume you're not going to get to its receipt until Wednesday or so. So you can do that and give me the counter numbers so I can then listen to it. How long is the argument going to be?
My opening
Yeah.
will probably be 3 or 4 hours.
And how long for the defense?
I would probably argue a total of a day and some. I'll probably argue as long as the combined arguments of Mr. Burt and Miss Lansing. So a day and an hour, a day and an hour and a half, something like that.
And how about the prosecution's close?
Well, it's hard to gauge how long I'll take in closing. I'll just give you a rough estimate, 2 hours.
All right. And there's still a couple instructions here you were working on, and
May I ask a question, a point of clarification? My understanding was that the court had agreed to give what we've labeled defendant special instruction number 16. It's based on People versus Horn. The fact that a killing was
Yeah.
planned in advance, whether individually or in concert.
well, I gave the instruction that was submitted by your co-counsel. I don't know what number it was.
Right, I'm not finding it
I'm not
easily in
either.
the court's packet of
Well,
instructions.
it's in the conspiracy
Okay.
instructions,
I didn't
which
see it.
follow the homicide instructions.
That may be why I didn't find it, because I stopped after the homicide. Yes.
You brought up that Horn instruction. There was one objection that I had to that Horn instruction, and that was that they left out a word, and that word is conclusively. And I'd ask that it be added to that instruction when I could find it.
Well, didn't we go through this with counsel a day or two ago, and they read the quotation, and the language here is exactly as it was?
Your Honor, the point that I attempted to make to the court was that although they parroted the language out of the Horn case, that language really amplified on what had been stated earlier. And that is that under the circumstances in Horn, where there had been apparently some planning, that doesn't conclusively prove premeditation and deliberation. What they've done then is they've left out the most important part of it. I think that in 95% of the cases, that in fact does prove premeditation and deliberation. So the jury would be in a situation where they would look at the court's instruction and say, well, wait a minute, that doesn't prove that there was premeditation and deliberation, even though there was planning all this time. So that was the only objection I had to that. And it's just a matter of adding the one word conclusively.
That's what should be heard.
Your Honor, I think that it's appropriate to give the instruction that we discussed that is from the case.
I'm going to give it as I gave it to the other jury. You know, we go through all of these instructions and debate about them, and almost all of them go unmentioned during argument. And so it's hard to know why we spend all this time. You expect the jurors to realize the fine points that you're bringing out during your discussions now, and you never mention it in your argument. So I don't know what the value of it all is. But the instruction I gave to the other jury will be the same instruction I give to this jury. All right, let's take a break so that counsel can go over the list of settled instructions that you gave me and verify that that is correct and accurately reflects what both sides have agreed to. And also you can complete your discussion regarding this other instruction.
Yeah,
your
12.
Evaluation of the one that we haven't evaluated yet or finished.
Right.
Your Honor, I can also give the court our special instructions, which correspond to the special instructions given for Lyle Menendez, so
Okay.
they can be included in the package.
There's one other matter
Oh,
that
but give me a copy
I
of
asked
them.
the court
so
to
I'll make it just
consider, and that is there were 4 notebooks brought in by the defense, the photographs. I'd asked that the court has looked at the photographs that we submitted, both the defense and the people. And I asked that they be marked as exhibits. I know that the court is not going to allow them to go to the jury, but I'd ask that they be marked as exhibits and
We would-
maintained.
Well, I don't know what he's asking, the 4 notebooks or the ones that were pulled out or both?
Both.
But Your Honor, we would object to putting our resource material as an exhibit and therefore taking it away from us. There may be a penalty trial, in which case we need access to those. There is no reason other than harassment to take all those family photographs.
What I will do is keep those photographs that were taken by both sides out of the notebooks and make those an exhibit.
What I would
As
like,
far as the notebooks themselves, I would order the defense counsel to maintain them in
Yes.
their current condition. And if there was a penalty phase, then those photographs could be used by either side.
Your Honor, what I would like to do is substitute Xerox copies for the ones that the court is marking as an exhibit if they're to remain part of the permanent file. Because I would like to have them back. We have promised the family the return of all of those photographs, and I would like to have the originals so they can be given back to them.
Okay,
So I
if you
will
want to make
Xerox them.
Xerox copies, that's fine.
Thank you.
Would those also be maintained, Your Honor?
Which,
The photographs?
yeah, they're
Till the
going, I
case
assume they're
is
going to be
over.
put back into the
The
original
notebooks, exactly.
notebook.
Yes.
All right, we'll be in recess
Thank
until
you.
counsel can complete their work.